All right. One last set of buttons to press. There we go. Good afternoon, everyone. This is 25 CV 017069. I should have asked Ms. Nichols, you good to be taking things down?
Yes, sir.
Excellent. I need you to interrupt whoever's talking, myself included, if for some reason someone here is not audible or you've got a bad reception to what's going on. Will you do that?
Yes, sir.
Great, thank you. This is the matter of Stacey Ian Humphreys as the petitioner versus the State Board of Pardons and Paroles and a whole bunch of other respondents. I'm going to want to get the appearances for the two sides, and then we will get into this. So I know there are a lot of lawyers here for Mr. Humphreys, and any number of you can talk, but really, I think for the court reporter, we need those who are most likely to be talking about what we're talking about today. So why don't we handle it that way? And if you need your name in the record for some other reason, you can let her know later that, hey, I was here on this day too. So good afternoon. Who do we have who's going to be speaking to the issue of, as I understand the issue, it's should tomorrow's clemency hearing be postponed through mandamus, through whatever we're going to call it, because of concerns about the composition of that board, and because there are always two sides to every story. Is three enough for a party? If two people don't participate or one doesn't participate, it sounds at least like one will be abstaining, which is different from recusing, and we'll work through all that. But that's what we're talking about today is the viability of having the clemency hearing at 9 a.m. tomorrow morning, which is 15 hours from now, whatever the math is. So who will be speaking on behalf of Mr. Humphreys?
Your Honor, I'm Jessica Sino from Crevlin and Horst. I'll be one of the lawyers speaking on behalf of Mr. Humphreys.
Great.
Thank you.
Zach Greenemeyer, also counsel for petitioner.
Can you say your last name again?
Greenemeyer.
Greenemeyer. All right. How do you envision dividing up what you're talking about? One of the members of the board versus the other member of the board, or what's the division of labor?
We have one more person talk.
Number three.
Number three.
Rahul Garabadu, Your Honor. And as we see it, Your Honor.
Go ahead.
Ms. Sino will be speaking to the argument. And if Your Honor will hear evidence, Mr. Greenemeyer and I will be divvying that up depending on the witnesses that may be testifying before you today.
Got it. Okay, that works.
I need y'all to type her name in chat real quick.
Yeah, so what we're going to do, Ms. Nichols, so folks aren't having to type and argue, is if we get your email address, we will send you the style of the case, the names of all the lawyers. There may be references to, Mr. Humphreys has a bevy of attorneys, and so there may be references to other lawyers. I don't want you worrying about how do we spell this or that. If you can get an email for my staff attorney, she'll get you all that info.
Thank you.
You're welcome. And on behalf of, I'm going to call it the state, but I know there are many moving parts to the state.
Respondents. Yes, Your Honor. Tina Piper, Senior Assistant Attorney General. I'll mainly be the one speaking today.
Great.
Conferring with my colleagues. Elizabeth Crowder, Senior Assistant Attorney General, as well as our Deputy Attorney General, Beth Burton.
Okay. Some of us have met before. So let me summarize what I understand the issue to be, and then we'll start with the petitioner and see where we go from there. So Mr. Humphreys is scheduled to be executed at 7 p.m. on Wednesday, but as is part of that process, he has a clemency hearing 9 a.m. tomorrow in front of the Board of Pardons and Paroles, which consists of 5 individuals, the chair being Ms. Holmes. And importantly to our discussion, 2 of the members of the Board of Pardons and Paroles are Mr. Bennett, who was at one point the sheriff of Glynn County, and that point would include the entirety of the death penalty trial of Mr. Humphreys, who was indicted in Cobb County, but because of pretrial publicity, the trial was moved to Glynn, Glynn County. And then Sheriff Bennett was responsible for security and transportation and whatnot for that trial. Another member, in a strange set of coincidences, of the current Board of Pardons and Paroles is Ms. McCoy, who happens to have been the victim witness advocate for that trial, meaning, from my experience as a former prosecutor, to include death penalty prosecution, someone who was intimately involved with the families of the 2 victims in that case. And so Mr. Humphreys has filed a series of pleadings that bring to everyone's attention what sure seems like the conflict that arises when someone who was so intimately involved with the victims' families of Mr. Humphreys' own trial would be sitting on the body that would be deciding whether he should be granting clemency. He should be granted clemency. And I thought this is going to be a fascinating debate until, of course, there are 2 sides to every story. I read the respondents' pleadings, and as it was represented to me, but we'll get all this on the record in open court, Ms. McCoy is going to be abstaining, as in not voting on whether Mr. Humphreys should be granted clemency. So it sounds like she would be present and would listen, but when it came time to vote up or down on clemency, her vote would be I abstain. Mr. Bennett would be participating, and the argument is that his connection to Mr. Humphreys' criminal proceedings back in 2007 in Glynn County don't rise to the level of needing to abstain or recuse or whatever we're going to end up calling it. So half of the concern raised by Mr. Humphreys seems to be addressed if Ms. McCoy isn't voting. But then, because these things are never that simple, there is the discussion of, can you have a hearing if one person won't be voting? Do you need to have 5 voting members so that the vote always adds up to 5? And how do we work through that? Or does Mr. Humphreys have a right to 5 individuals who could, if they were so inclined, vote to grant him clemency? Or is he at some disability because there'll be only 4 people or potentially 3 people if Mr. Bennett wasn't going to be voting as to whether Mr. Humphreys should be granted clemency. So we've got the procedural pieces of what makes a quorum. Is someone entitled to more than the 3? And also the question of, should Ms. McCoy and Mr. Bennett be participating at all? And if so, in what way? I'm sure I've missed some of the pieces. You guys are much more steeped in it, but we're not here. That's what I thought when I heard you have something about an upcoming execution to talk about the Attorney General's commitment not to execute anyone until certain things were met after COVID. Apparently, Judge May got to handle all that in federal court. Thank you, Judge May. And we are focused on the issue of what should happen tomorrow at 9 a.m., who should be in the room, or should nothing happen, and we need to reconstitute on a temporary basis the board so that Mr. Humphreys has 5 people at the table, none of whom labors under any conflict, real or perceived, by the public. With that, Ms. Sino, why don't we start with argument, and then you can get into, really to flesh this out, I feel like I need to ask Mr. Bennett some questions, and I still want to ask Ms. McCoy questions, even though she's abstaining, or however you guys want to proceed. It's functionally your hearing, and then obviously Ms. Piper and team will respond on behalf of the respondents.
Thank you. Well, good afternoon, Your Honor. I very much appreciate you hearing this on an emergency basis and also being thoroughly versed in the background for this. And I will say, as Mr. Humphreys' counsel, we're not entirely sure what the position of the state is because the respondent's brief is a 4-person board is just fine. 1 member can abstain. We can move forward. However, and I'm not sure you're aware, roughly an hour before this hearing started, there was a stay of execution issued in this matter, which I think we agree potentially postpones tomorrow's clemency hearing. So we're not sure of the import of that.
Talk to me a little, I'm not aware. I don't have the Humphreys hot
It's news to us.
on my phone. So I was in a meeting and then I was saying, I have to be in court. Who stayed the execution?
That was the Board of Pardons, the State Board of Pardons and Paroles. If you may, I can present
Sure.
this to you because we received it as we were leaving for court.
Okay. It has a gold seal.
It does. It's fancy. Yeah. Okay, and while it says it's a stay of execution, they have informed the Federal Public Defender's Office that it is also a stay of the clemency hearing that is going on tomorrow. So,
Okay,
so it is not occurring tomorrow, but we don't know anything beyond that.
Okay, why don't you pause, but you can stay right there.
Okay.
And Ms. Piper, fill us in as much as you know. And I appreciate in situations like this, things are happening real time. And so you may say, Judge, you know what I know.
Basically, you know what I know. I will say that there is not a time for the suspension. So, it's only effective right now.
Okay,
Okay, it can go, the longest, the maximum it can go is 90 days. All right.
could, I'm sorry to interrupt, but just so I'm understanding the parameters, could Chair Holmes, upon a vote of the board, issue another one of these in an hour saying, never mind, it's unsuspended. He better be there at 7 p.m. on Wednesday.
That's a really ongoing, fast, off the cuff, factual question for the board. I think that they could, would they? I can't answer for the board, but I doubt it.
Okay.
I doubt that would occur.
Okay. What do you know about why this happened?
The board does not, the board guards its votes, and I'm sure you're aware, everything official business the board does is guarded zealously. It's a state secret. They're not.
I do know we've had to litigate this in other cases. And why didn't this guy get parole? None of your business is what we're told.
They are zealous in protecting the privacy to afford individuals the most, objective review that they can do.
Oh, and I respect that. I didn't mean to probe in that way. Like, hey, who voted for this? I'm curious if there was some indication as to not who thought it was a good idea or a bad idea, but we are suspending because we need to do X, we need to do Y. That would give everyone a better sense of, for example, do we need to do this hearing? Do we need to do it today? Or would we reconvene in a week or a month? And in between now and then, petitioners, lawyers might be able to learn some information that would make their argument moot, or who knows. But it sounds like you didn't get along with this, a little memo saying, hey, here's why we did this.
That is correct.
Okay.
And I will say, just factually, even if they were to, as your hypothetical, at any point, file a new order saying, we are going to have a hearing on this date, I think we still have to go forward with the legal issue before you court.
Okay. And from your experience, when they unsuspend things, do they unsuspend and say, we'll see everyone in 20 minutes for the clemency hearing? Or there's a week's notice, or
Yeah, I don't know that I can give you an exact time frame, but it's not the 20 minutes. I mean, it certainly is, you know, they would get the same notice they would get anyway, normally, I would think. So, you know, there's,
I haven't been on death row before, so I don't know what kind of notice you get for, hey, now is the execution date and T minus 3 days is your clemency hearing, or how that goes.
If I may, Ms. Smith, who is the in-house counsel essentially for the board, is on Zoom.
Okay.
She may have some information.
Oh, right, Ms. Smith. This is the Ms. Smith
Yeah.
that one of you emailed to say we've got an issue, and nope, there's no issue. We're going forward.
Correct.
Ms. Smith, are you able to hear us?
Yes, Your Honor, I am.
Hey, thank you for joining us. Are you in a position to answer any of the questions that I had, such as how do we figure out why things were suspended? I bet I know the answer to that, which is no. But how much notice people get when the suspension is lifted?
So I may be able to answer, Your Honor. In this instance, I don't believe that there's any law regarding the amount of notice a person gets when the stay or the suspension is lifted. We would provide at least 24 hours notice, if not, depending on whether the window for execution is still open, obviously, to provide counsel an opportunity to get themselves and any staff that is assisting present to the appointment, which would likely be, like I said, maybe 24 hours in advance of the appointment date, should the stay or the suspension be lifted.
But if there's supposed to be a clemency hearing before the execution, then I guess the execution would have to be at least 2 days out, because you'd have the clemency hearing in between the lifting of the suspension and the execution.
That's correct, sir.
Okay. All right. But as of right now, you don't have any information you can share with the parties to this litigation as to whether this is a short-term suspension, a long-term suspension, or we wait for the next gold seal document.
That's correct, sir.
The last one?
I'm sorry. I don't have any information as to how long this suspension will last.
Okay. All right. Well, you didn't know you were going to be put on the spot. Thank you for pitching in here. That's helpful. Okay. We should go forward.
We should.
Because we don't know
this.
when we'll all be together again.
Well, and the execution warrant is open till the 24th, and there's a massive amount of logistics of getting other witnesses here for the clemency hearing. So
The 24th of December.
correct.
How does that work? An execution warrant is valid for?
A certain window, and so they could potentially say, hey, stay would be lifted tomorrow. Clemency hearing, execution is on the 23rd. We're going to have a clemency hearing on the 22nd.
If
And
we go past the 24th, then there needs to be a new execution warrant?
that is correct, Your
And
Honor.
is that what the district attorney applies for, or who? So Ms. Allen out of Cobb would say, all right, we have to do this
We have to-
again. I'm getting a new execution warrant. But is that merely a matter, I don't mean to make it sound insignificant, but he's been sentenced. So getting another warrant, some judge doesn't have discretion to say, I'm not going to give you an execution warrant.
Yeah, that's a more ministerial function, but it's also a large, over the holidays especially, a scheduling function, given that there are mental health experts on behalf of the defendant and other individuals who have to fly in. And
None of this is simple. I get that.
Exactly.
And so no one should hopefully be thinking, well, we'll just give everyone 24 hours notice. I want to be mindful as we're working through this, the significance of if something pushes past December 24th, one can get another execution warrant, and that's not moving a mountain. What's moving a mountain is the execution and the clemency hearing and being prepared for that.
Correct.
Okay.
Yes.
All right.
Yep. Okay.
So let's assume that we're going forward.
Yes. Thank you. So this mandamus action is necessary because the state, we'll say, intends to proceed at some point with a clemency process that is plainly unconstitutional and cannot be remedied through ordinary channels. And this court does have the authority to compel compliance with the Georgia Constitution.
If Ms. McCoy doesn't participate, and by that I'm going to just say she's there the whole time, but she doesn't vote. That's how I take abstain. Abstain would be, I'm in the room, I might even ask some questions of witnesses, et cetera, but when it's time to vote, the vote is abstain.
Yeah.
If that's the approach that the board takes, which is what's been represented in signed pleadings that have been filed with the court, so that there are 4 people, and I appreciate you've got concerns about Mr. Bennett, we'll air those out. What's unconstitutional about that happening?
So, and it's a great question. The Georgia Constitution mandates there shall be a state board of pardons and paroles, which consists of 5 members. And that's Article 4, Section 2. And it further requires in capital cases, the full board have an opportunity to hear the application of a convicted person. So the provision requires that clemency in a death penalty case has to be considered by a fully constituted 5-member board, not a partial one, not a conflicted one, and having all 5 participating members. It was recognized 10 days ago by the board's counsel, Ms. Smith, saying there have to be 5 members.
Well, but Ms. Smith isn't the Constitution, and so she said what she
Correct.
said. If the Constitution says that 5 must hear it, that might explain why Ms. McCoy would be given the advice of you should abstain as opposed to recusing, which I would take to mean I'm not going to be in the room while it happens. And so then 4 people would hear Mr. Humphreys' plea for clemency, and that would be inconsistent with constitutional language that says the full board must hear the application. But Ms. McCoy could hear it if she's abstaining. She's just not voting on it. I know that sounds ticky-tacky, but words have meaning.
But they do. And sorry, I don't want to interrupt
No,
you.
but so the full board hears it, and then Ms. McCoy says, I'm going to abstain. I ought not to vote on this because I have some conflicts that kind of hit you in the face when you read about her connection to the underlying case that brings Mr. Humphreys before us.
And they do. And so if you even dig deeper, so the board has a policy, board policy 1.120, that members, it focuses right on members are participating in proceedings. And so the impartiality, if it's reasonably questioned, they do have to abstain, but a member is prohibited from participating. They are not exercising their constitutional power of clemency at all. And so the board cannot be constitutionally whole. And they make this distinction, I think, if you look at Fugate, for example, which this court decided in 2002.
And so we're clear, this court means Judge Goger.
Judge Goger,
Not Judge
you,
McBurney, not a judge
you.
back then.
Right.
But you did, I looked at Fugate, that was in some of your pleadings. Does a policy of the board constitute either, and it may be both, a law that a judge could issue a mandamus on, you must comply with this law? Or is it a policy? And it's not a court's job to enforce a policy. And if it somehow is, well, start with that.
Okay, so I do think that policies are part of what we recognize that the board has to comply with. There are structures and norms for a board that they have to follow, especially when it comes to conflicts in this specific instance, right? And we're looking at what are these ethical guidelines that are clear, and when clemency is exercised, when we're looking at participation, deliberation, and voting for in these particular instances. And so those norms and guidelines help establish when a board member, for example, is conflicted, when there's an appearance of a conflict, and when it is the right time for that board member to not be participating in a procedure.
And what's the specific language of the policy? If I, as a board member, conclude that I have a conflict, like Ms. McCoy has, apparently, she's abstaining. Does the policy say you should abstain? Does it say you shouldn't participate? And then that's open to the interpretation of, well, abstention means you're not participating. So she's checked the box of the policy, but you still have a full board because all 5 are in the room when the clemency petition is being presented.
So if you read at under board policy, so the first board policy that we start with, which is 1.105, that the employees shall make every effort to avoid even the appearance of a conflict of interest. And it goes on to say that it's when a reasonable person would conclude from, I feel like there's a question coming.
No. With Ms. McCoy, I'm glad we're not having to have the argument. How does someone not see the conflict here?
Okay.
And that was addressed with the pleading from the respondent. So she's raised her hand saying, I've got a conflict.
Okay.
And so she's going to abstain.
All right.
How is that approach to her conflict inconsistent with the policy?
So 1.106, an employee shall recuse him or herself from any proceedings. It isn't abstain, it is recuse.
And what's the difference?
So abstain is, I still stay in the room. I can listen to all of this information, but I'm an empty seat. I don't vote on it. There's only 4 people who are there. Recusing is generally, I'm taking myself out of the room. I'm not participating in these proceedings. And it's like, for example, if a judge recuses from a case, we don't have an empty chair with this hearing going on. We have a new judge that's appointed in your stead.
Do you have any examples of recusals on the board where someone said, I have to recuse, that's my nephew who's coming in, so I can't be handling his request for clemency. And you know what they did in that case is that board member McBurney leaves and they bring in board member Jones, a new person temporarily. Like you're going to sit in for this hearing. That's it. You don't stay on the board. You are here temporarily because McBurney had to recuse because it's his nephew. So
I'd love to say that I did. These guidelines are relatively recent, so there aren't a prime example of that occurring just yet. Part of some of the questions that we have to adduce in evidence are, were you provided with these guidelines in advance when you were onboarded, for example, as a new board member?
Okay.
Yeah.
So your argument is that the policy says it says you shall recuse, and recusal is not abstention. Recusal would mean you're not even in the mix. And so if Ms. McCoy is saying, I've got a conflict, she's not complying with the policy if she merely abstains. Words mean something. She should recuse, which means she's not present at all, in which case you don't have a full board. You have 4. Setting aside whether Mr. Bennett has a conflict as well, you're already at a point where contrary to the Constitution, the full board's not hearing the application.
Your Honor, you're making my argument for me, but yes.
I just want to make sure I understand it.
That is right. That's absolutely right.
So,
and if I may add, it's slightly different from the argument in respondent's brief where they're using quorum to justify that they don't need to have all 5 members. And that's a different component of this.
okay. Are you going to get to that? Because
Yes.
okay.
Yes.
All right.
So part of the respondent tries to sort of use, if there are 3 out of 5 board members that are available and can preside over this, then you've reached the amount that you needed and will be fine. But that is simply the amount you need for quorum to be able for that clemency proceeding to go forward. It is not what is required and it's certainly not what Fugate has stated, it doesn't negate the requirement, and this is straight from Fugate, which is in the next sentence that they left out of their brief. It does not negate the requirement of 5 appointed board members, members of the board at all times, who are to have an opportunity as required by the Constitution to consider applications for themselves.
This quorum, 3 out of 5 would be a quorum. Are there rules that talk about the board conducting business with a quorum, or is the quorum, that's the number of votes you need? I think of quorum as we now have enough people in the room to conduct business. And if there are any rules that talk about there being a quorum, I mean, it would seem to be unnecessary. If the Constitution says you have to have everyone there, then your quorum is everyone. It's not 3, it's not 4. Where does the notion of quorum come from in terms of the operations of the board?
Sure.
I know it's in the respondent's brief. I got that, but I don't remember if they cite to, well, Rule 1.101 says a quorum is enough. 3, you can go forward.
So in the, I believe it is later in, one of my colleagues may bring this up to me, but I know there is a section about as long as you've got 3 out of 5 members to.
While you're looking, let me ask
forward.
Ms. Niles a quick question.
Great.
Okay, I was just thinking that bus station's not a thing. Oh, he has cases from that district? Okay, that is real. That's fine. I just want to make sure he's not like, hey, there's this bus stop or something there.
I'm ready when you are.
Thank you. So the quorum, it requires a quorum of a 5-member board to act, which is, I believe, the 3 out of 5 members to grant the clemency petition.
Okay. To act as in 3 have to vote for it, or they need
Yeah,
3 in the
3 have-
room to do it?
You need 3 to vote for it.
I didn't say that well. You just repeated me, so I'm the one who didn't
I
say it well.
apologize.
No. But there need to be 3 votes in favor of X for X to occur with the board, not that 3 people have to cast a vote, so that a 2-to-1 vote would actually carry the day. You see the difference between the two?
That's right. So under the Georgia Constitution, you have to have, you can't, for example, if there are, let's say, just 4 people, it can't be a 2-to-2.
That would be a tie.
That would be a tie.
Right.
You can't have 2-to-2. It would have to be, for example, it always has to be at least 3 voting in favor of clemency. So it has to be 3 to 5, 3 out of the 5 voting for that.
But what you read to me sounds like you could just have 3 people in the room, and if they vote unanimously, that's 3 votes, and that carries the day. And if you had 3 people in the room, 2-to-1 wouldn't work because that's
2-to-1.
not 3.
Correct.
Okay.
It has to be at least 3 in favor of clemency.
Okay. All right. I'm ready.
Okay. Yeah, so there's the. Okay. It's attached to our pleading, right? Is it attached to our pleading?
Yes, it is. It's
Okay.
number 14. It's exhibit 11.
Okay. So exhibit 11 attached to our pleading is the fugate order that has the discussion at page. I think it's page 5. About needing the fully constituted board members.
Respondent's suggestion that the quorum rule anticipates a board vacancy does not square with the Constitution's mandate that the full board consider clemency applications.
So if you, okay, the quorum rules, OCGA 4297. Quorum rules are established by OCGA 4297. And that was the same issue that came up in Fugate, where again, the respondents there attempted to argue that the statutory rights were not violated by having 4 board members presiding over the clemency hearing, which constitutes a quorum, because the quorum was established by 4297. The court held in Fugate that construing constitutional and statutory provisions together, the quorum rules are applied to determine just the necessary number of presiding board members, given the constitutional requirement for a fully constituted board, which is 5 members. And that although only 3 of the board members need to preside over a hearing to constitute a proper quorum, this does not negate the requirement of 5 appointed members of the board at all times who are to have the opportunity as required by the Constitution to consider applications for themselves. And it goes on to say quorum rules were established by the legislature. The people of the state of Georgia voted on the constitutional guarantee of 5 members of the board of pardons and paroles. Hence, in order to respect citizens' expectations, the court must strictly construe a constitutional guarantee of 5 board members, especially in light of the possible irreparable harm to the defendant.
So I guess we've sort of come full circle.
We're coming full circle.
The Constitution in Article 4, Section 2 says that the full board, not a quorum, the full board, to me, that says all 5, shall have an opportunity to hear the application. But if Ms. McCoy is sitting in there, she's hearing it. I guess your argument is to what end if she's not going to vote? That is honoring the word of the Constitution, but not the spirit of the Constitution. She doesn't have the ability, if in her heart the vote is X, to cast that vote if she's abstaining.
Correct.
Okay.
It has to be 5 board members. It has to follow the Constitution, and you can't escape that by using 4297.
Okay.
And she can't abstain. She has to recuse, and there has to be a new board member.
What about Mr. Bennett?
Mr. Bennett.
And I guess I should be clearer. What I mean specifically is help me understand why then Sheriff Bennett doing his job, apparently doing it well. The trial went off and there didn't seem to have been security issues there. Conflicts him out of being a participant in the clemency hearing.
So part of a large chunk of the clemency process will focus on the juror deliberations at the penalty phase.
It's people pounding on the wall and crying, and there was actual hole in the wall.
Correct. And Mr. Bennett was in fact present and around the jurors during that process, which our contention, and we would like to adduce evidence from him regarding some of that, because it makes him privy to more of that, not just more of that information, but also the emotions that run high during that period of time. Penalty phases are incredibly difficult times of trial.
And this trial went as in Georgia death penalty trials should, same jury deciding penalty. They didn't bring in a different jury. So the jurors who found Mr. Humphreys guilty then labored through the sentencing phase. And so jurors who are getting emotional in the deliberation room are the same ones who found him guilty. Okay. All right.
And he also had personal interaction with Mr. Humphreys as well, obviously prisoner transport, other courtroom interactions.
Okay. So you would like to elicit some evidence from Mr. Bennett?
Correct.
Okay. Ms. Piper, any issue with that? I know, I think it was Ms. Crowder maybe who reached out, someone from your team reached out via email. And I said Zoom participation's fine if people are far away. It seems like there is a factual component on Mr. Bennett's side to this, what we need to, as a group, evaluate on the conflict piece. This has nothing to do with quorum and abstain and whatnot. You'll get an opportunity to respond to all of that. But I'd like to hear a little bit more about his connection to the trial and even what he remembers about it.
We anticipated that you would.
Okay.
We have absolutely no objection to him talking about his lack of personal involvement.
Okay.
It's just-
I don't want you to coach the witness. Mr. Bennett, I see your name on the screen. Are you able to have your camera turn on and your microphone?
Yes, Your Honor.
All right, so I can hear you, but you're a black box, so we'll need to figure out how to get that camera to work. Do you all have any technically trained agents near Mr. Bennett? I saw them. What is this? It's full blown warrants. Okay. Okay. Mr. Bennett, you gonna be
Yes,
able?
sir.
We don't have any video from you.
The video button, maybe?
me try this. No.
Mr. Bennett, can you see us on your screen?
Yes, I can.
All right. Do you have a screen that has a camera?
In the past, it worked okay, but it's apparently not functioning correctly right now.
Did you perhaps maybe accidentally turn the camera off, hit a button or something at the top? Or swipe the top of
Okay,
the laptop?
is it working now?
Whoops. I just hit the wrong button. Try one more time. Nope, you're still a black box. You don't happen to have any kids in the house? They're the ones who always make this work for me.
You're exactly right. I wish I had a grandchild here with me right now. We wouldn't have any issues.
Perhaps you could get him on his phone.
Yeah, I don't know. Some people, when they get stuck like this, they'll dial in on a separate device, one for audio and one for video.
Can you do that, Mr. Bennett?
Yes, I'm going to try to call my office to speak with IT.
Okay,
Is that okay?
it is. So we're going to take a quick break. I have 2 search warrants. I'm going to quickly peruse for Investigator Wilson. All right, let me peruse these and then we'll get you up here.
Off the record.
Yes, ma'am.
Thank you.
Okay.
Okay, someone needs to send me all these appearances. Y'all said y'all were going to email them to me. When people speak, I need to identify them as we're going along.
All right, Ms. Karen Shack put something in the text saying she did just that. Those are the 3 lawyers whose names you got are all colleagues of Ms. Karen Shack's. She said she sent you an email.
I do. A 8D defendant, SCA 8D prosecutor. I see Miss Piper, but I see somebody sitting next to her. So if y'all could just email me all your team members, somebody for the defendant or respondent, however you want to be identified. And I do have that email from Zara, but I just need everybody that's at the council table.
Ms. Nichols, can we get your email address, please?
Yes, I'll paste it again in chat.
Thank you.
And it is, hold on just a second. It's Laura, LauraNichols @bellsouth.net. And can I ask who ordered the court reporter? Do y'all need a transcript expedited? I just need to know what to expect so I can have a team working. Okay, there's Mr. Bennett.
We ordered it. This is Tita Piper with the Attorney General, and yes, we would like that. Oh, Zach ordered. We'll share.
Okay, so y'all are splitting the cost of the court reporter and both want an expedited transcript. Is that correct?
Yes, ma'am.
Mr. Greenemeyer, is that correct?
Yes, it is.
Okay, thank you.
Sorry, I didn't get through it before we got our share. Are you good for a little while longer? You're good? Okay, you can watch this hearing. All right, Mr. Bennett, how are you doing?
I think we are ready to go, Your Honor.
Great. Thank you for finding a grandkid to make it work. All right, I'm gonna have the deputy swear you in, and then I think we're pivoting with lawyers because Ms. Sino said she doesn't do evidence, she does argument. All right, but first, if you'll raise your right hand.
Raise your right hand. Do you swear or affirm the testimony you shall give to the court today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Okay, you may lower your hand. Please state and spell your full name for the courts.
Yes, my name is Wayne Vernon Bennett. It's Wayne Vernon Bennett.
Thank you.
And from where are you joining us, Mr. Bennett?
St. Simons Island, Georgia.
Wow, we should have had court with you. That's what we should have done. I'll come join you. All right, we appreciate you making time for this. Counsel?
And does the court mind if I sit so I can?
As long as the court reporter can hear you, I'm good.
All right. And Mr. Bennett, can you hear me okay?
I can.
All right, beautiful. You are currently the vice chair of the State Board of Pardons and Parole, correct?
That is correct.
And you come into this role after a long and varied and successful career in law enforcement?
Yes, sir.
All right, and I want to show you just for the record what I believe is your bio. Can you see that? First off, Mr. Bennett, can you just see what's on the screen? This document.
I can.
Okay. All right. And I can scroll as quickly or as slowly as you would like, but does this appear to be your bio on the State Board of Pardons and Parole website?
Yes, sir, it is.
Okay. And this details some of your accomplishments as a law enforcement officer, including as a sheriff, correct?
That's correct.
All right. And then we would move to admit this as Plaintiff's Exhibit 22.
So do you have copies to give to respondents, and do you have an exhibit list? Because 22, I have exhibits 1 through 14 that were part of one of your pleadings, but I think they were really appendices. Oh, look at this. Never mind. Binder. All right. Exhibit 22. And Ms. Piper, are you handling this part of the proceedings as well?
No objection.
No objection. 22 is admitted.
Thank you, Mr. Bennett. And getting into it, you were the sheriff of Glynn County throughout the 2007 trial of Mr. State v. Humphreys, correct?
That's correct.
And as we just alluded to, the trial was not held in Cobb County where the offenses occurred, but instead in your county, in your sheriff's office, correct?
That's correct.
And your office had a number of roles in facilitating this trial, correct?
That is correct.
You were responsible for courthouse security.
Yeah, it come under the direction of my office.
Correct. And your office was responsible for housing Mr. Humphreys at the jail, right?
That is correct. And
your office was responsible for transporting Mr. Humphreys to and from court each and every day of a long trial, correct?
Yes, sir.
In addition, I understand that there were a couple of extra roles for the sheriff's office due to the nature of this case. In this instance, the jury was sequestered, right?
That is correct.
And the sheriff's office coordinated security at the hotel for the jurors, right?
Yes, sir.
And they arranged for that housing for the jury for the over a month the trial was going on?
That is correct.
They arranged for the jury's meals?
Yes, sir.
And they took precautions with regard to the television, newspapers, visitors, telephone calls that these jurors had, right?
Well, as common practice, we would confer with the presiding judge to get the stipulations that he or she would place on the jurors, and we would abide by those rules.
And in fact, in this instance, jurors were instructed or encouraged, or somehow they monitored, to not inadvertently gain access to information from the media, newspaper, and television. Correct?
Yeah, that would be correct.
And the sheriff's office was responsible for either limiting or screening visitors to the jurors during their sequestration?
Normally, visitors aren't allowed. In some cases, they are allowed to talk with their families by telephone. And I do not recall exactly what the stipulations were placed on that particular jury.
Okay. Now, I may be able to show you some documents to refresh your recollection, but does it sound right to you that the jurors were limited to phone calls of 5 minutes of duration that were in the presence of the sheriff's office personnel during the course of this trial?
Correct. That's correct. That's usually the normal procedure.
Okay. All right, I want to show you another exhibit, which is Exhibit 7, which is in our petition. And can you see this?
I can see, I would actually need to enlarge it just a little bit.
Yes, sir. And please aggressively instruct me to make it bigger, go up, go down, whatever you need. Okay. So you can see this right.
Okay, it's pretty clear now.
Okay. And let me know if you want to read more of the first page before I go on to the second page.
Okay, it's, I'm not really familiar with that correspondence as it would have gone to my courthouse staff, which I believe at the time was Major John Scott.
Okay. But you would agree that this letter is addressed to you, correct?
That's correct.
It outlines some of the sharing of responsibilities between the Cobb deputies and the Glenn Sheriff's Office deputies in the course of this trial, correct?
Yeah, that's correct.
All right. And we would move to admit Exhibit 7.
Any objection to Petitioner 7?
No objection.
All right. And I want to show you another letter. All right, can you see this document? Not yet, I guess. All right. So this appears to me to be a October 4th, 2007 letter from you to, it appears, and correct me if I'm wrong, that you wrote to each of the jurors in this case.
Yes, that's a standard form letter that we send out to the jurors in all of our jury cases that helps us evaluate our job performance and things that we could do in the future to make their stay a little bit more comfortable, especially with the sequestered jurors, and it's to get their input as to what could be made better in our policy.
Okay. And we would move to admit Exhibit 8.
Any objection to Petitioner's 8? And Mr. Bennett, you're saying this letter, while it's customized to this trial, was fairly typical outreach from your office to jurors? Because it looks like it's, other than explaining a few things to jurors once their service is complete, you're looking for feedback. What could we do better next time so that the experience goes a little better for you, the juror?
Yes, we're, as an organization, we're always looking for ways to improve our services to the people that we represent, and this is a tool that we use to try to meet those requirements.
And
I'm sorry, is that exhibit received in evidence?
Yes, it is. Mr. Bennett, would you say that this is typical to send out a letter like this, or it would just be in the longer trials, or what percentage of the cases for which your team provided juror security and whatnot, would you send out a letter like this?
Well, anytime that we had a sitting jury, we would send out letters very much similar to this one.
When you say a sitting jury, meaning a jury that heard a trial, not sequestered, but any trial?
Actually, when they actually heard a trial.
Okay, thank you.
Okay. Am I good to go, Judge?
You are.
Okay. Okay. So I see in this letter some set of, customization or tailoring to the facts here. I would imagine not every jury in Glynn County is sequestered, correct?
I'm sorry, did you say every jury is sequestered in Glynn County?
I would say I imagine that's not the case, right?
Oh, that's not the case, no.
Right. And looking in the, last, I guess, full paragraph, right? It says, for you as a juror, it has been difficult being separated from your daily routine with your family and friends. You continue, however, you and your fellow jurors have been an exemplary group to work with. Is that standardized language that you include in every letter, or was that tailored to the unique circumstances presented by this jury?
I would say it's pretty much standard wording. However, there is time to time that there are some issues that would come up during the trials.
Okay. Okay. Setting aside the the correspondence with the jury, but fair to say from the perspective of the Glynn County Sheriff's Office, this was a significant and complicated undertaking for the Sheriff's Office to, in addition to the day-to-day responsibilities of conducting a jury trial, to deal with the unique circumstances presented by a sequestered jury. Would that be fair?
I'm going to object. Counsel's testifying. There's not a question in there. A lot of testimony.
So, technically you have this person kind of on direct examination. I appreciate you wanting to get through all this, but you should ask him what he remembers, what his connection was, et cetera.
And Your Honor, if it's possible, we would like to, this is a party opponent, to treat this as cross for.
Okay, no, fair enough. I'm thinking about who is suing whom. So, okay. All right, so the question was just, would you agree with me that this is a significant and complicated undertaking for the Sheriff's Office that wasn't presented by your day-to-day administration of the jail and the... Meaning managing the sequestered jury for a month-long trial?
Correct.
Okay.
It takes a considerable amount of more planning in doing a sequestered juror, but it's not beyond our ability to make sure everything goes smoothly and the needs of the jurors are met, and keeping the presiding judge informed as to any abnormalities in the jury room that we may be aware of. But we at the time we were quite familiar with sequestered juries as well as death penalty cases.
Yes, sir. All right, a couple questions about Mr. Humphreys at the jail for his stay in Glynn County. Before he got there, did you speak with the Cobb County Sheriff about Mr. Humphreys?
I'm sure that I would have had a conversation with the judge, the sheriff, and as well as the undersheriff, because I personally knew them, to find out if there's any particular needs of this inmate and just get an overall view of what to expect from him or family members, which is routine to do.
Okay. And what about with Judge Robinson, who wrote the letter that we looked at earlier to you in Exhibit 7? Did you ever talk with her about Mr. Humphreys?
The best I recall, it was very brief when she arrived at our courthouse. I can't say verbatim what our discussion was, but I was inquiring about any special needs of her court as to how I need to perform, or my employees had to perform during the duration of this trial.
And were you involved in designating the security classification or any specific, changes to standard security procedure for Mr. Humphreys while he was in your detention center?
We had a written protocol policy that would define how the inmate would be transported, would be handled, and if there were any special instructions from the court or from the sheriff in Cobb County, and the appropriate employees would take charge of that.
Okay. And do you recall any departures from standard policy and procedure that were put in place for Mr. Humphrey specifically?
No, I don't.
Okay. Did you receive any information or come to any conclusions about whether Mr. Humphreys posed a particular flight risk while, or either before or while he was in your custody?
No, our facility, it was a maximum security facility. My deputies and detention officers are well trained, and I had all the confidence that any situation that would arise, that they could handle it properly and efficiently and professionally.
And if there were any departures from standard policy or procedure, would that be something that ultimately would be for your approval?
I would be made aware of any situations out of the norm, and we would discuss it, of course, and take appropriate action.
All right, so I want to show you.
Sure. Something not in the binder.
This is something that's not in the binder. Okay. And this is a packet of 46 pages that were received from the Galena County Sheriff's Office about Mr. Humphreys' time there. And I got a couple questions about it.
I'm going to object until there's a foundation laid that he has any knowledge about these documents he's being asked about.
Okay, well, they haven't been tendered yet, but sounds like you're going to need to lay a foundation if you want to tender them. You may be using these to refresh his recollection. I'm not sure, but proceed accordingly.
Thank you. Do you see what's on this page right now, which is page 38 of the PDF?
I see the instructions from the initial agency to our office as to the history of the inmate.
Okay. And this is your understanding that this is something that came from Cobb County to Glenn County, but not something that Glenn County generated. Is that right?
That's correct.
Okay. Do y'all have this has been a number of years, but it says he will be housed into, it looks like DR 112. Did y'all have a cell DR 112?
Well, at the time we did. The actual facility no longer exists, but it was where we kept people in cells. They were cells made for the individual, not to general population.
Okay. And you would agree that this document says that must exercise extreme caution with Mr. Humphrey, correct? Mr. Humphreys?
That's the notation in the memo.
And later refers to him as extremely dangerous.
Yes, when you're handling a death penalty case, most of the verbiage in these MO memorandums of understanding with the inmate is pretty standard.
Okay. And then I want to show you on the page before that. This looks like an email involving Mr. Corbett, the undersheriff that you referenced earlier.
That's correct.
And in addition, you see here that he refers to Mr. Humphreys as very large in stature.
Yes.
Okay. And I want to go to the last page on here. This looks like a Glenn County Detention Center medical administration record. I don't have any questions about the medicine here, but I do have a question about this notification here. It says no female contact at all. How did that come to be made part of his medical record?
I really do not have a definite answer for that, but considering the charges against the inmate, precautions would have to be taken to ensure the safety not only of Mr. Humphreys, but my employees as well.
Okay. And you would agree that just where it lists where Mr. Humphreys is assigned, it's DR 112. Do you see that?
Yes, I do.
Okay.
Was there a question to that, please?
No, sorry, I apologize. I was conferring with counsel. All right, so what conversations do you recall having with Mr. Humphreys?
I would say absolutely none. At that particular time, we were housing in the excess of 400 inmates. I had very little one-on-one contact with the inmates, especially the inmates that were in a high custody unit.
Mr. Bennett, I'm going to pop in here for a second just so I can get some perspective. I'm familiar with a very, very large sheriff's office being here in Fulton. And I know just from having had productive conversations with our sheriff that his organization is so large, and necessarily so, that his answer to a question of did you ever have a conversation with an inmate would be invariably no, because I'm making the number up, a 500-person business. And if I go to the jail, it's to meet with the jailer and the top command, but I'm not interacting with inmates in the courthouse. I'm not interacting with them in transit. I'm not interacting with them in the jail. Glenn County is smaller, but it's not teeny. And so I'm wondering, in the ordinary course of the work you did for the 30 years you were sheriff, if 20 years you were sheriff, if you routinely had conversations with inmates.
Oh, I would have conversations with inmates from time to time, but they were in the lower security units. I was always accompanied by staff, but the ones that are in the high security units, and I think we had approximately 32 individual cells where they were very restricted on the time outside the cell, which was only 1 hour per day for exercise and just to be able to be outside of the cell and to shower. So my time going through that unit was very small, except for more or less to inspect the area as far as physical condition.
Would you ever have been one of the individuals directly, personally involved with transporting Mr. Humphreys from your jail to the courthouse and back?
No, sir, not at all.
And when Mr. Humphreys was in the courthouse for his trial, would you have been regularly interacting with him? Just checking on you, Mr. Humphreys, want to make sure you're okay?
No, sir, I would not.
So if you had to guesstimate on fingers the number of conversations you had with Mr. Humphreys, can you fit it on one hand? Is it two hands? Do we need to get to toes?
I would say absolutely zero.
Okay. What about members of Ms. Williams or Ms. Brown's family? Those are our two victims. Would you have interacted with those families very regularly?
No, sir, not at all.
Okay.
Even though we're small, that courthouse, there was still regular activity in the courtrooms, which we have 3 superior courts on that floor where Mr. Humphreys was being tried, and those courtrooms were filled on a daily basis, and the public was in the rotunda and going throughout the courtrooms and the grand jury rooms and what have you.
Okay. Thank you.
Was it the case that when Mr. Humphrey's trial was going on, are you saying that there was court happening in the neighboring courtrooms, or was when Mr. Humphrey's trial was going on, that was the only business being conducted in the court that day?
No, there was other courts in session. They're all individual courtrooms.
Okay. And how often would you set foot in the courtroom where Mr. Humphrey's trial was taking place during the course of that trial? Would that be an everyday thing, a never thing, in between?
I really couldn't put a number on it. If I went into the courtroom during Mr. Humphrey's trial, probably less than 5 times.
You were, or your office was responsible not just for housing Mr. Humphreys, but also for making sure he had haircuts and clean court clothes and the like?
Usually the request for haircuts and personal hygiene issues, the clothing, anything else, usually came from the attorneys.
Okay, but your office would be responsible for making sure that those attorneys' requests, provided they were reasonable, were made happen.
Yes, we were self-contained. We had barbers, doctors, psychologists, psychiatrists. We were a city within a city.
And during this process, even if you're not having conversations with Mr. Humphreys, were you able to observe, were you able to see him throughout the course of the trial and, the time that he was at the jail?
I don't recall seeing him. I testified earlier, we had 400 plus inmates in our custody, and I had a lot of responsibilities for the whole facility, as well as my responsibilities outside in the unincorporated areas of Glenn County.
So you wouldn't be able to see his affect or his emotions when he was at in the custody of Glenn County, either when he was at the jail or he was in the courtroom. Is that what you're saying?
Could you repeat that question, please?
Yeah. Were you able to just observe his affect or his emotions throughout the weeks that he was present with you or with your office during the course of the trial?
Not as I recall, but if I did, it was any sighting of him was unremarkable to me.
Okay. You have no recollection specifically?
No, I do not.
Talk a little bit about your office's dealings with the jurors. So we talked about sequestration and some of the issues there. I got a couple questions about the meals. So I would imagine your office is for some meals, bringing food to the jurors?
We would cater inside. It depended on the presiding judge. If they wanted to have lunch at the courthouse or if they wanted to have dinner at the courthouse, that was handled on a daily basis. We also would transport the jurors to restaurants in our community.
Okay. You anticipated my next question. Did you ever share a meal with the jurors during this process?
No.
And, in reference to the judge's, questions earlier, Blaine County is not Fulton County, but it's also not a small county. I imagine you, as the elected sheriff, might have had some familiarity with some of the jurors before their service. Do you recall whether you knew any of these jurors?
The information that I've been reading for the past month, I saw the names, but I'm not familiar with any of the jurors.
Okay, so you've seen the list of the jurors at some point in the last month, and you're saying that you don't recognize any of those folks.
That's correct.
Okay. And during the course of their sequestration, we talked in that letter about taking precautions with newspapers, televisions, visitors, phone calls. I imagine sometimes that might be frustrating for the jurors to have their lives interrupted in that way. Did you ever have any conversations with those jurors about those frustrations and just how to manage them or why all these rules were in place?
I personally did not have any interaction with the jurors. My staff would have been exposed to any questions or requests by the jurors, and if they were not already agreed upon with the presiding judge, then it would be forwarded to the judge to get guidance on how they would like to accommodate the jurors.
Okay, and then would your people then report that to you, what was going on with the jurors during this time?
No, I had full confidence in their ability to do their job professionally in the way they were trained to do it.
And then, for security in the courtroom, you testified you may have been in the courtroom for 5 or so days during the course of the trial. Does that sound right?
That's a misstatement of evidence.
Excuse me, Mr. Bennett, if I didn't recall correctly, how many times would you say you estimated that you were in the courtroom where Mr. Humphreys was being tried?
I really can't give a positive number. If I think I stated I may have been in the courthouse maybe 5 times during the time period. I really do not know. I have business with the judges, the DA's office, in the jail from time to time, and my times at the courthouse would be inclusive in that number 5 if that was during that time period.
And at some point, I understand that deliberations amongst the jurors got heated. My question to you is, how did you become aware of that?
I probably late in the afternoon when when the court was in recess. But it's not unusual for the jurors to have disagreements, the jurors to become vocal. When you're away from your family and you're living with 14 other people, 12 jurors and 2 alternates, when you start exceeding 3 days, it gets a little tense, but it's human nature, and we deal with it accordingly. And the judge is always made fully aware of the issues going on.
Yeah, and help us understand that a little bit. So I understand, you mentioned tension. Understand that. I understand here there's instances of screaming and crying in the record. Were you aware that the tension escalated to that point of where jurors were audibly screaming and crying?
I don't recall on this particular case. It has been brought to my attention in other cases, but it becomes pretty much routine after you've been in this business as long as I had, and you know how to deal with it, and you take the precautions and you try to find the remedies to bring everyone back in line and to proceed with their assigned task.
And yeah, talk us through a little bit about, based on your extensive experience, how your people or you yourself would support jurors or make sure that things weren't crossing a line in the course of that tense deliberation.
Well, that actually would be under the guidance of the presiding judge. Normally, the jurors would be returned to the jury box, and the judge would address the situation.
Okay. In this instance, I guess at some point a juror threw a punch that connected with the wall of the jury room. How did you hear about that?
I really didn't hear about it until I read it in the lawsuit in the past few weeks.
Okay. So depending on the circumstances, throwing a punch that damages government property, that could be potentially a criminal offense, right?
I'm not sure a punch was actually thrown. I have not seen or had any direct testimony to say that that happened.
So that's my next question. Did you or any of your people investigate what was going on and inside that jury room, at least as far as potential act of violence?
If it was determined that there was an act of violence and someone was hurt or there was a violation of state law, it initially would be brought to the judge's attention, and then we would proceed from there.
Do you know who made the repair to that wall? Was that something that the sheriff's office personnel would have done, or is that something that the court would have done? Court personnel.
We
I'm
have,
going to object. He's already stated he was unaware of a hole in the wall in this trial, and you're asking who repaired it.
Let's stay focused on Mr. Bennett's potential connection to Mr. Humphreys' trial, Mr. Humphreys, the victims' families, the jurors.
Were you, Mr. Bennett, aware of what the source of the strife within the jury deliberations was? Were you aware that it concerned whether it belonged to a particular juror or whether it about their position or whether it had something to do with food or family? Did you know anything about that?
could I ask you to repeat that question, please?
Yes, sir. And I apologize for asking a poor question. Were you aware of the source of the strife within the deliberations? Was it a particular, did you know whether it was a particular juror or not?
We do not get involved with the deliberations of the jurors. Our job, of course, is to secure and protect the jurors and have them places where they need to be. We do not get involved in deliberations or anything outside of our scopes unless it's asked of us by the presiding judge.
And just to be clear on this, if there was in fact a hole in the wall, would you generally expect to have been made aware of that as the person ultimately in charge of courtroom security?
Well, the hole was actually made in the wall. It's strictly cosmetic, and the trial is more important for us to control, and we can fix that hole in that wall at a later date.
But if there was a punch thrown that damaged the courtroom wall, would you generally expect to have learned that information during the trial?
If it in fact happened, I would assume that I would have been made aware of it by the staff, and the staff would have been directed to confer with the judge for information, and the judge would advise us one way or the other as to they would like for us to proceed.
Understood. And again, just to be totally clear, your testimony is you do not have any recollection of receiving that report at the time, right?
I do not.
Okay. Almost done, Mr. Bennett. Thank you for your patience. I want to come back to that letter. This is Exhibit 8. And in the last bit, it says, if I or any of my staff can ever be of assistance to you, please do not hesitate to call. Did any of the jurors call you or ask for assistance in the future?
No, they have not.
Okay. And
not that I recall.
Sure. And did you get any responses back to the survey in this instance?
As a general rule, with all the letters we send out to the jurors, we get a very good response back, and it's mostly constructive criticism. We do get complaints about the meals, of course, and other things that we really don't have any control over. But it is used as a constructive tool for us.
And I understand that as a
we try to direct them as to where they can get an answer to the question.
Understood. And I understand that to be as a general matter. Do you have any specific recollection one way or the other of whether you received survey responses from the jurors in Mr. Humphreys' trial?
I do not. It's been quite some time since that trial, and I would have to go back and pull those records to see if they even exist.
And would you be willing to share those with us if they do in fact exist? Or share them with your counsel at least?
If I'm directed by the courts, I will be glad to share it with you.
Okay. And so I understand your, from your earlier testimony, it appears that you may have reviewed or at least received Mr. Humphreys' clemency petition already. Is that true?
I have.
Okay. And I asked a bad question. I asked whether you had received and reviewed it. Have you both received it and reviewed it?
I have received it, and I have been making myself aware of the case through the transcripts, the statements from the jurors, the doctors, other attorneys. It's quite large in volume, and it's taken a little time to do, but it's going to be accomplished by hearing date.
When is the hearing date?
I have no clue.
Thought I'd try.
Nice.
And I appreciate your thoughtful review of that. As you may be aware at this point, one of the big issues in the clemency application is Humphrey's team says there was a hole in the wall, and maybe the other side is going to say there wasn't a hole in the wall. Would you agree that you are in a position to know facts about that question that is not the same as the other members of the board?
Your question is not, does he know them now, but he has the ability to learn more about it?
The question is, do you, Mr. Bennett, have more information that might help answer that question from your role in 2007 in the courthouse as compared to the members of the Board of Pardons and Parole who were not in the courthouse in Glynn County in 2007?
And I'm gonna object because he's already asked and answered about his knowledge of the whole.
Right. Next question. While you're thinking of your next question, Mr. Bennett, when you received the clemency application from Mr. Humphreys' lawyers, and all you knew when you first got it is it says Stacey Humphreys, did that name mean anything to you, or was it not until you got into the file and, oh, wait, I was here for that case?
Well, Your Honor, I actually had prior knowledge, just maybe a few weeks, that this situation was coming up before the board. And when I saw his name, I recognized his name. But prior to that, if you would have asked me about a trial from Cobb County, I would have had to look at documents to become familiar with it.
Okay.
Right. And Mr. Bennett, we've looked at, and I can show you again, the ethical rules for the Board of Pardon and Parole. Do you receive these as part of your onboarding when you came onto this board in 2024?
I was educated from the day that I came on board to this very day today as to policies and procedures. And it's like any other profession, it changes and you need to be kept up to date. And I feel like have been well versed on the procedures of the board.
Okay. And you would agree that as part of your role, it is important to be free from any conflicts of interest, correct?
That's correct.
As well as free from any outside influences, which could influence your ability to perform your duties.
I perform my duties because I deal with facts and evidence, and to be, my mission is to be fair, honest, but firm. And I take all those factors into consideration in making any decision.
And how many death cases, death penalty cases, occurred while you were sheriff of Glynn County for the 20-year tenure?
Well, when I was actually a Glynn County policeman, I was directly involved with death penalty cases where I was involved in the investigation, or I oversaw the investigation as the commander of the Criminal Investigative Division. As sheriff, I recall at least 3 death penalty cases, and all 3 of those were change of venue cases. They were brought to our county to be tried.
Do you recall the names of the people who were on trial in those 3 cases, besides Mr. Humphreys?
Object relevancy.
Stop for 1 second. Response?
I did not recall any of the names.
Hold on, Mr. Bennett.
I'll withdraw the question.
Okay.
Yeah.
All right.
And you testified a moment ago that when you received the clemency petition from Mr. Humphreys, you recognized his name. Is that right?
That's correct.
What, if anything, did you do with that information? Did you inform anyone that you knew something about this case?
The best of my recollection, I informed our executive director as well as our legal staff when I heard about the Cobb County case, and I indicated that was probably the case that was a change of venue brought to Glynn County.
Okay, and was that, sorry, excuse me, I didn't mean to cut you off.
And that just turned out to be so that it was Mr. Humphreys' case coming from Cobb County.
Okay, and was that before December 4th when Mr. Humphreys' team reached out to Ms. Smith to flag what Mr. Humphreys contends is a potential conflict involving your involvement?
No, not at that time. I don't believe that the dates, and I don't have any information as to when Ms. Smith was notified of my conversations with our executive director to my participation in the trial.
Okay. And so your understanding is that whatever, was brought to Ms. Smith's attention was separate and apart from you raising this issue or asking the question about your knowledge of the Humphreys trial that you brought up with the executive director. Is that right?
If I understand your question correctly, I was concerned at that particular time of any standing that I would have in making a decision on Mr. Humphreys because of all my lack of participation. Mr. Humphreys' trial was minimal at best.
Okay. And then this was something that you just wanted to raise regardless of the limited involvement. Is that right?
Well, first it started out as a general conversation, but then as we talked about it in the following weeks, I became aware that it could be a point of law with the Constitution, and we have worked closely together in resolving it.
Okay. And was there a point where you were concerned that maybe you would not be an appropriate person to decide Mr. Humphrey's case, his clemency application, based on the specific facts and involvement that you had?
Well, it's my thought that we need to abide by the law and the Constitution, and I think that's why we're here today, for our judge to make a decision, and whatever his decision is, and that's what I'm going to accept and abide by.
Understood, and certainly appreciate it. Do you recall when this first conversation took place, where you raised this issue with the executive director?
No, I do not.
Okay. Was that in this month, in the last 2 weeks, or was it before that?
I'd say it was in the last 60 days.
Okay.
I can't pinpoint it. I'm not trying to be evasive. I just can't pinpoint it because I've had so many conversations about so many different things with our executive director.
No, that's very appreciated. And so you can narrow it down to within the last 60 days. To me, that says that you think it was longer than 14 days ago.
I'm going to object. He's badgering the witness. Witness has said he doesn't know, and he's been pushed into giving the 60-day, and we just keep pushing.
Okay, I don't think we've reached the badgering stage yet, but you can ask this question, then we'll move on to another topic. Do you need him to repeat the question?
Yeah, if you would, please.
Yeah, sorry. When you said 60 days, I mean, do you think it's closer to 60 days ago or 30 days ago? Or do you think it's possible that the first time you ever talked about this with anyone was 10 days ago?
It's really so difficult to say. We have so many conversations, not only with myself and just the executive director, but as the board in general. I don't document these conversations as to the date and time and the length of the conversation. So I cannot definitely say when, where, and how long these incidents took place.
Understood. All right. So I understand your representation earlier that whatever the court tells you to do, you're going to do. But do you have an opinion, a personal opinion, about whether you should serve as a decider of Mr. Humphrey's fate in this matter, based on your connection to the trial in 2007 in Glenn County?
I don't think my connection with the trial has any bearing on me as a board member making a decision from the evidence that we will review and the testimony that we will hear during that hearing. As I mentioned before, I'm a factual person. I believe in the evidence and the rule of law, and that's what I go by. I don't go I can't bring in past experience from 18 years ago that would make up my mind or my decision process one way or the other.
Thank you, Mr. Bennett, for the patience and for your testimony. I don't have any more questions for you at this time.
Ms. Piper, do you have any questions for Mr. Bennett?
Your Honor, if I may, just a few short.
Sure. You may. I just, I don't, you should go for it.
Thank you. Hi, Mr. Bennett.
Right.
I have just a few questions regarding, and the next series of questions I'm going to ask are going to relate to 2007. So we can just assume this is at the time of the trial. Can you tell the judge, approximately how many deputies do you think were employed by you as a sheriff in 2007?
Are you referring to actually certified police officer deputies or
Yes.
detention officers included in that?
I'm referring specifically to individuals who would have been certified to provide court security or security as a jury.
For court security, I would say at that time, maybe 45 to 50 actually deputies that could be put in a position to serve for transportation and security at the courthouse.
And in your experience in 2007, was it uncommon for cases to get transferred to Glenn County from another county?
No. And I think the judge alluded to it earlier. It's not a bad place to be. And we did have, and still do have, a reputation of having a very secure jail and a secure courthouse.
And did you ever provide security during any time during Humphreys' trial in the courtroom?
No, it was all the duties of my staff to perform those duties.
And what about security at the Holiday Inn? Did you personally provide security at any time during the trial of Mr. Humphreys?
No, I did not.
And when you said you, under the normal course of business, would have talked to the Cobb sheriffs, I believe your exact words, to discuss particular needs of an inmate. Can you just flesh out what you mean by particular needs? What you would find out from the transferring county about an inmate typically?
The gist of the conversation would have been and probably was of anything out of the common attitude of the inmate, his abilities to abscond, his abilities to resist, and of any special needs. We needed to know if he was ambulatory and the medications he was taking, which would be transferred to his medical file. But we try very hard to be prepared for the inmates coming to our facility so that we can properly care for them.
And was that a routine discussion you would have for any transferring?
It was done that way each and every time.
All right. And speaking of each and every time, I want to jump over to the letter, the how we do letter, and ask you just a couple of questions on that. You indicated it was a form letter that was slightly altered for each of the juries. Who actually altered, let's say, or manipulated that form to send to each of the juries? Was that you? Did you personally participate in manipulating those forms so that they could go out?
Well, actually, there were several different forms. It depended on the type of case that was heard by the jurors. Sometimes the jury was only in session for hours, and sometimes for weeks. And maybe on one or two occasions, it exceeded the 30-day mark. So you would alter the letter that would pertain to that particular case.
And did you personally alter those letters? Did you go on the computer and alter those letters? That's what I'm asking.
I wouldn't say I'd go in the computer, but I'd say that I would have some advice and some input. It just depended on the case.
Okay. And those letters invited a response. You're soliciting, how'd we do? You're soliciting information. Do you have any recollection of receiving any responses? You were asked about phone calls, but do you have a recollection of any written responses related to the Humphreys trial that you would have received?
No, ma'am, I do not.
I believe those are my questions, Your Honor.
All right. Any follow-up from petitioner's side?
Just one moment, Your Honor.
Okay.
And Mr. Bennett, in your tenure as a board member, which for the entirety of your tenure, have you declared a conflict at any point while serving on the Board of Pardons and Parole?
No, I have not.
Okay. Have you signed the conflict awareness affidavit?
No, I have not.
Okay.
Are you talking about in this particular case or?
In any case.
No, none.
Okay. All right. Thank you.
Mr. Bennett, I have one question. When you say executive director, is that Ms. Smith? Who's the executive director for the board?
Chris Barnett.
Okay.
Ms. Smith is our legal counsel.
Got it. Okay. Mr. Bennett, thank you for making yourself available. You're welcome to stay on the Zoom session. You can, if you know how, you can turn the camera off. You're welcome to leave it on. I'm going to take you off the main screen, but I appreciate you being present for this.
Thank you, Your Honor.
All right. Any other evidence that you all want to take at this time?
Yes, Your Honor. We'd like to call Ms. McCoy.
Why?
Your Honor, up until about less than 24 hours ago, Ms. McCoy was going to be hearing clemency application of Mr. Humphreys. Overnight, we found out that that was not going to be the case anymore. However, in order to perfect the record and to understand the nature of the conflict, whether or not Ms. McCoy discussed this case with others on the board, and to learn what exactly abstention might mean, we would like to ask for a couple of questions regarding those topics.
So that would be 6 questions, 3 topics, a couple each.
Well, I wish I could promise you it'll be 6 questions, Your Honor, but I don't know if it'll be exactly that many, but we'd like to have the opportunity to develop the factual record on that piece.
Okay. I'm going to hear from Ms. Piper in a moment, but my thought is you don't need to ask any questions about the conflict. It's really clear. But it's fair, it'd be fair to ask about that. I just don't think it's necessary. I think it is appropriate to ask about what would abstention mean in your mind. Your second 2 topics, you should explore those. How do you see procedurally this working? You sit there and you never say anything, or you participate fully and you don't vote. So explore that. And your other topic of what have you told others about your knowledge about the Humphreys case? Those 2, feel free to explore. But I'm going to ask you to leave the other one alone, in part because you could go all day establishing the conflict. It's that broad, it's that deep, it's that obvious, so you don't need to. Okay? All right.
Okay, I don't know who is speaking for the petitioner.
And I can go up to the podium.
Okay, we'll fix that. We'll fix that in a minute. It's always been the same person. It's the 3rd name that you got on the list. That's Mr. Garabadu. And I'll have him come up to the podium in a minute. But before he does that, Ms. Piper, any objection to having Ms. McCoy testify about the 2 areas? Mr. Garabadu identified 3. I'm saying let's talk about 2. Any objection to that?
I would do a general relevance. She's conflicted out, right? She is said, I'm abstaining from the vote. You know, if Your Honor would like to hear information on that, I would just ask that it be limited as you have a limited.
Okay, well, great. We'll do it my way. Why don't you come on up, and Ms. McCoy, if you could turn your camera on, please. There she is. Thank you, Ms. McCoy. Whoa, we don't have a deputy right now. I'll swear you in. Raise your right hand. Do you swear or affirm that the contents of your testimony will be true and correct to the best of your belief and knowledge? Nope, that's the wrong oath. That's if you had an affidavit. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Excellent. Let's follow that one. She's under oath.
All right. Good afternoon, Ms. McCoy. Can you see me on one of the 18 different cameras that are?
You know what? I can make that happen. If you'll move that screen a little bit, the podium screen works, and then angle it up. There we go. And then we'll add, there we go. And why don't you state your name one more time for our court reporter?
Rahul Garabadu for the petitioner.
And she's already got your name. So now we'll go.
Great. Good afternoon, Ms. McCoy. I'm going to be asking you a few questions about, on behalf of my client, Mr. Humphreys. Now, Ms. McCoy, you served as director of the Victim Witness Unit for the Cobb County DA's office from April of 1999 to April of 2024. Is that right?
That's correct.
All right. And just to be clear, you're an employee of the Cobb DA's office in that role, right?
That is correct.
Okay. So you're paid by the Cobb DA's office?
Cobb County government, yes, Cobb County DA's office.
Okay. And you were appointed to the State Board of Pardons and Paroles by Governor Kemp effective December 1st, 2025, right?
That is correct.
So it is your second full week, or we're going into your third full week on the job.
Yes.
Now, Your Honor, I am showing the witness what's been marked as Exhibit 2 on the screen.
Is this 2 also from your binder, or
Yes,
it's a different?
It is 2 on the binder. It's
Okay.
2. I'm going to share my screen. Ms. McCoy, can you see the document I'm displaying for you right now that says the State of Georgia Executive Order at the top?
I can.
All right. And do you recognize this document?
I do.
And this is a document that appoints you as a member of the State Board of Pardon and Paroles. Is that right?
Can you scroll down so I can see the remainder of the document?
Yes. And let me know if I need to zoom out too. I can do that as well.
That appears to be the document, yes.
Okay. Your Honor, we move Exhibit 2 into evidence.
Any objection?
No objection.
All right. It's still official. You started as of December 1.
Yes, sir.
Now, Ms. McCoy, did you apply for a position on the board, or did someone reach out to you about the appointment?
I'm going to object to relevance on this question, and we're going outside the scope of the narrow topics you asked to.
So you can talk to me about how it's relevant, but then there's 2 topics. It's how do you envision your role in this clemency hearing, this one, Humphreys? Yes. And what, if anything, have you shared with other members of the board, or do you plan to share with other members of the board about what you, meaning Ms. McCoy, knows about the Humphreys case trial?
Yes, Your Honor. This is just leading up to kind of parole on the board, and then we are getting to the abstention piece and the communicating piece. But I just want to understand, how she came to be in that position. If that involved other members of the board, for example, that might be relevant as to what Ms. McCoy might have shared with them before coming onto the board. With the bar for relevance being so low, Your Honor, I'd ask for a little leeway here.
Okay, it's a low bar. You have a little leeway, but let's get to our two topics.
Yes, Your Honor. So, Ms. McCoy, did you apply for a position on the board, or did someone reach out to you about the appointment? How did you get to be on the Board of Pardons and Paroles?
I had several people reach out to me asking me if I would consider the appointment or consider being considered for the appointment. I had a former elected district attorney, retired district attorney, who submitted my name for nomination.
Okay, and who were the folks who reached out to you about considering a position on the board?
I don't.
Listen. Yeah, you weren't here.
I'm sorry. Am I to answer the question?
Go ahead, Ms. McCoy.
I don't know that I can tell you everybody that asked me if I would consider being nominated, because some of that happened at a retirement party. There were numerous people there. I was asked by retired district attorney. No, I'm sorry. That is not who I was asked by.
Well, let me make the question a little easier for you then, Ms. McCoy. Did any of the current members of the Board of Pardons and Paroles reach out to you about applying for the position?
No.
Okay. I want to talk to you a little bit about how the board handles clemency applications generally. When the board receives a clemency application, how is it processed by the board?
I can't answer that question in generalities because this is my third week on the job and this is the first application for clemency I've seen.
And I'm going to object. That doesn't sound like one of those two topics.
We're getting there, Your Honor.
Boy, it's an indirect way of getting there. I'm going to ask you a question, Ms. McCoy. Have you discussed with any of the other four members of the board your knowledge about Mr. Humphreys' case?
My knowledge about the case? No, sir.
Okay. The way you answered my question suggests you've discussed something else about the Humphreys case with the other board members. What would that be?
My only discussion with any of the board members has been with Mr. Bennett, and that discussion was the lawsuit that was filed.
The lawsuit meaning what we're doing right now?
Yes, sir.
Okay. Gosh, that's a harsh name for it. No one's being sued like we're going to get damages. They're doing what they need to do on behalf of their client, but I guess it named you, so it feels like you're being sued. On your first day on the job?
Yes, sir.
Okay. 11. But in terms of substance, sitting down with the board member saying, man, let me tell you about the Humphreys trial. I was there. I sat with Ms. Williams' family, Ms. Brown's family. Nothing like that's happened.
No, sir.
Okay. That's one of the two topics.
Yes, Your Honor. And just following up on that question, did you ever bring it up with the ethics officer of the board about your involvement in the Humphreys trial?
I discussed this with internal counsel LaQuan Smith and with executive director Chris Barnett.
Is there a separate ethics officer, or is Ms. Smith effectively as counsel? That's who you'd go to saying, hey, there could be an issue with the fact that I was the victim witness advocate in this case.
Correct.
Okay.
That's right. Okay.
But I want to make sure you don't think, counsel, that there is also an ethics officer that Ms. McCoy didn't go to.
No. My question was whether or not Ms. McCoy consulted with Ms. Smith.
Okay.
And it sounds like she did.
Okay.
And Ms. McCoy, when did you have that conversation with Ms. Smith?
May I look at a calendar?
You may. I guess you only have 11 days to choose from.
Yes, sir. To the best of my recollection, that was December the 4th.
December the 4th. And did that conversation happen right after you heard that Mr. Humphreys' clemency application was going to be reviewed by the board? Let me make that question a little simpler. When did you find out that Mr. Humphreys' clemency application was being heard by the board?
I found out that the death warrant was signed on, I believe it was December the 2nd.
Okay.
And did that trigger in your mind that, that means I'm going to be dealing with this because death warrant means clemency hearing?
Yes, sir.
Okay.
Okay. So when you heard about the death warrant being signed, that was what triggered your conversation with Ms. Smith?
That triggered my conversation with Executive Director Barnett.
Okay. And what did you discuss with Executive Director Barnett?
That I needed to advise him that I was the advocate assigned on the case back in 2007, that I would await direction from the board's legal counsel as to whether or not there needed to be further discussion about that, just general conversation about how to proceed.
And did you receive guidance from either Mr. Barnett or Ms. Smith after that conversation?
I did.
Okay. When did you hear kind of about your next steps as it related to Mr. Humphreys' clemency application?
We had several conversations. I'm sorry, I can't tell you exact dates. I mean, we had conversations even deep into the weekend.
Okay. Do you remember if this was, again, 11 days to choose from, would this have been your first full week as a board member or your second full week? Can you remember, or was it that weekend straddling those 2 weeks?
I'm sorry, I don't understand your question.
I guess I'm just trying to ask, do you remember if it was closer to your first day on the job or if it was this past week?
I have had general conversations with Executive Director Barnett and with Ms. Smith since December the 2nd.
Okay. And based on that conversation, did either Mr. Barnett or Ms. Smith tell you that you needed to recuse yourself from the case?
I'm hesitating because I don't recall those exact words being said.
What do you recall being said as it related to your participation in the Humphreys clemency application?
That I took an oath as a board member of the State Board of Pardons and Paroles, that I swore under oath to uphold the rules of the board, that any knowledge that I might have had of the case could be different from information that is provided to me during the clemency hearing. I had some discussions with Ms. Smith about my involvement with the case. General conversation about board procedures. I'm sorry, I don't know specifically. Those are the things that I have had conversations about.
If the clemency hearing were to have gone forward tomorrow at 9 a.m., what were you planning on doing? Were you going to be in the room with headphones on, not in the room? What would you be doing?
I have not had that thought, sir, because I have abstained, and then this morning I knew that there was a stay, so I have not had that thought.
Okay. Tell me what you mean when you say you abstained.
That I abstained from the vote in the clemency decision.
Okay. But does that mean you wouldn't be present for that particular hearing? And so the other four would take care of it, or you'd be there, but when it was time to vote, you would say the word abstain rather than yes or no, or I don't know what words, grant, deny, but you wouldn't be saying any of those words. You'd say the word abstain.
The only conversations that I had with how that would happen was with the Attorney General's office.
Okay, well, I don't want to get into that. But I guess, so you haven't reached a vision in your mind as to what your participation, because this will happen. There will be a clemency hearing for Mr. Humphreys. And I need to understand, given the lawsuit, as you called it, that's in front of me, what does it mean for you to abstain? Are you going to be there and do what everyone else does except vote? Are you there but you sit mute? Are you not there at all? Those are different.
Yes, sir. My answer to your question is I'm going to do what the court directs me to do.
You sound a lot like Mr. Bennett, but I want to get it right. And I may not have to direct you at all if you were saying, you know, I actually get a day off from Board of Pardons and Paroles work on Mr. Humphreys' clemency hearing day because I'm not going to be there because I'll be, to use your word, I'll be abstaining and you'll be going about your life in a different way. But it sounds like that hasn't necessarily crystallized for you what abstaining means.
That is correct, sir, because I have, as I told the board in the AG's office, would be awaiting direction as to what I needed to do.
Okay. I appreciate that. Thank you.
Ms. McCoy, when exactly was the decision made that you were going to abstain from the clemency application hearing?
Last night.
Last night, okay. In your conversations and in your considerations regarding the Humphreys clemency application, did you consult the ethical guidelines for the Board of Pardons and Paroles?
Will you repeat the first part of that question? I apologize.
Sure. You've indicated today in court that you've spent some portion of the last 2 weeks thinking about the Humphreys clemency application and what you might do. As part of those considerations, did you consult the ethical guidelines of the Board of Pardons and Paroles?
I read over them, yes.
Okay. And you'd be familiar with them if I showed them to you right now?
Yes.
Your Honor, I'm showing the witness what's been marked as Exhibit 14, which are the Board of Pardon and Parole's ethical guidelines. Ms. McCoy, can you see my screen?
Yes.
Okay. And I'm going to scroll through this, and you can tell me to slow down if you need me to.
Can you make it larger, please?
Yes. Is that large enough? Do you need it larger?
Yes, thank you.
Okay. And tell me if I need to go slower in scrolling through this.
So that looks like it's lots of pages. Are you going to go to a specific spot?
I am. I just want to confirm that this is Ms. McCoy, does this look like a fair and accurate copy of the ethical guidelines that
Ms. Piper, you're not challenging that this is not a copy. Great. It's a copy.
All right. Your Honor, this time we'd move to enter these ethical guidelines into evidence.
Do they have an exhibit number?
Yes,
You may
they're
have said
Exhibit
that.
14. I'm sorry.
Exhibit 14. There they are. Any objection to petitioners 14? Admitted.
Okay. Now, Ms. McCoy, I want to direct you to Rule 1.105.2, which I'm going to scroll to right now. All right. Do you see Rule 1.105.2?
I do.
Okay. Now that rule notes that employees should make every effort to avoid even the appearance of a conflict of interest, right?
Yes. May I have 1 minute to read this, please?
Absolutely.
While she's reading this, question for you, Counselor. Given that Ms. McCoy is abstaining, whatever that turns out to mean, why are we exploring this?
Your Honor, I think we haven't quite gotten to the bottom of what led to the decision to abstain. And so I'm trying to get a little more clarity through the ethical guidelines as to what Ms. McCoy might have consulted to get to that question of what abstention is.
But don't you have the dilemma for you that what Ms. McCoy has said is, I talked to the executive director, I talked to counsel, then I talked to the attorney general. And the result of that conversation was that I'm abstaining. And so what led her to abstain was, as the record stands right now, the attorney general's office and I had a conversation, the substance of which we may not explore, lawyer, client. So I don't want, and I think Ms. McCoy doesn't want to, not in the sense that she's not wanting to give full answers, but she knows that it's a privileged conversation. So you're bumping up against that.
Yeah.
May I also object on relevancy, but let's assume for sake of argument, there was some violation. The violation of the policy is not what we're talking about here.
Well, because she's abstaining, whatever abstaining means.
Right.
So why don't you go ahead and ask a question, but I just don't want poor Ms. McCoy to get by like, well, that's not the whole thing, and I should read 1.1053. She may feel on the spot, I'm getting quizzed on the ethical guidelines, and that's not what, I know that's not what you're intending, but I just don't want her to be in that position because it's not where we're going with this anyway.
Yes, Your Honor. And to be very clear, I'm not asking Ms. McCoy to breach attorney-client privilege at all.
Good.
What I heard in Ms. McCoy's earlier answer was that she was given a lot of information from Mr. Barnett, from Ms. Smith, that she took into consideration. She was then given, it sounded like before I asked her these questions, she had looked at these rules, and it was only when the Attorney General conversation took place that was what triggered the abstention. And so what we're trying to get to the bottom of is, was it the lawsuit that triggered the abstention? And if so,
then so what? I don't, just to cut to the chase, how does that affect the decision you want me to make? Whether it was the lawsuit or she looked at, hey, I better look at my horoscope today. Oop, don't commit an ethical violation.
Well, Your Honor, it goes to the question of whether or not the conflicts of interest, whether it's in Ms. McCoy's case or Mr. Bennett's case, are actually being implemented by the board.
And in a larger picture, that might be something that someone might want to explore, but we're here for Mr. Humphreys. And Ms. McCoy has said, I won't be participating at a minimum in the vote as to clemency. So why don't you ask two more questions about, because you said you're asking couples. Yeah. Ask a couple questions about this, and then we're going to move on from the ethical guidelines, because Ms. McCoy has reached the point that you were advocating for. Mm-hmm. At least she's not going to vote. Whether she's going to not be in the room, we're going to figure that out.
Yes. Yes, Your Honor. And in that case, Ms. McCoy, I actually want to direct your attention then to Rule 1.106.2, which talks about recusal. All right, Ms. McCoy, can you see 1.106.2, the rule about recusal?
Yes.
So Ms. McCoy, that rule talks about when a board member needs to recuse themselves. And it mentions the term, right underneath that, it mentions the term, it defines the term participant. And it says that a participant includes, but is not limited to, a person, an owner, shareholder, partner, employee, or agent of a business entity involved in the proceeding. So recusing under that definition means you can't be involved in the proceeding. Is that your understanding?
I'm going to object that we're getting into having this witness who, the relevance of what she defines as a word in a policy as irrelevant to these proceedings.
Your Honor, if I may.
You may.
This goes back to what the daylight between recusal versus abstention.
Okay. I am overruling the objection. Can you scroll it up or down? I want to, there we go. Great. Okay.
So Ms. McCoy, do you, as a member of a board, see a difference between recusal, which under these definitions says that you could not be involved in any proceeding, versus abstention?
I'm going to object to recusal is not defined that way. Participation may be defined a certain way, but recusal is not defined in such a manner. And that's misstating the evidence.
When you look at 106.2, Ms. McCoy, no, don't roll it away. What does the word recuse say to you? If you felt you were in a situation to which that provision applies, oh, that's me, I need to recuse. What are you doing? If you are recusing, tell me what it is you think you're doing.
Removing myself from the situation.
That's good. But now put that in concrete terms. I don't go to that meeting. I don't talk about it at all. I'm completely walled off for that one situation. You can give me all the other cases, or you're there with everyone else, but you aren't particularly participative when they're talking about that case.
A recusal means completely walled off from the issue at hand. However, if you continue to read 1.106.2, it says because of an employee's personal or financial relationship. That is the basis of the recusal.
Okay. I see what it says. I was focused on the fourth word there, recuse, and because you have said I'm abstaining and you didn't say recuse, you said abstain. And you can understand why I'm trying to figure out, well, what does abstain mean? Because abstain isn't what it says anywhere in the policy you're supposed to do if there's a conflict. It says recuse. I don't think it's a coincidence that your attorneys, for the purposes of this litigation, the Attorney General's office, said you'd be abstaining. They didn't say recuse. They're smart people. They choose their words carefully, and they said that you'd be abstaining. And so that's why we're going around and around on this.
Yes, sir.
All right. Any other questions?
Just to follow up on that point. So, Ms. McCoy, you did not believe that you had personal involvement in the Humphreys trial?
I had involvement with the Humphreys trial because I was the assigned advocate to work that case at the time.
So is that a yes to my question? You did not think that was a personal involvement of yours?
It was not a personal involvement in that I was employed as a victim advocate at the time of that case. I was assigned as the victim advocate in that case, and I performed my roles as a victim advocate pursuant to the Crime Victims Bill of Rights in that case.
Okay. Your Honor, may I confer with my co-counsel for a moment?
You may. Deputy Gordon, could you grab this? It goes to Ms. McAdams. I think she may be outside. Make sure I got the right name. Yeah, Ms. McAdams. Thanks.
Your Honor, may we take a 5-minute break to confer and come back? Would that be okay?
I bet you that Investigator Wilson would appreciate that because then I can read his warrants and get him out the door. He's learned more about abstain versus recusal than he ever wanted to. You all right with that, Ms. Piper, if we take a few-minute break?
Yes, Your Honor.
Okay. When we get back, you should not have many questions left for Ms. McCoy, given what we all agreed you'd be exploring with her.
The 5-minute break will help to ensure.
Validate?
Yes.
Okay. All right. We're off the record for a few minutes. I'm gonna go read these. When I come back out, I'll swear you in, okay? Thanks. Appreciate your patience. I hope you're on the clock at least. Good.
Y'all, I didn't understand the word, the something Bill of Rights.
Crime victims.
Crime victims, yeah.
Crime victims, thank you.
Sometimes that word.
Right.
Ms. Piper, is the name of this hearing remote emergency petition for a writ of mandamus and complaint for injunction, or is that the hearing that y'all are preparing for?
No, this, you have it right.
Okay, thank you.
Okay.
Okay, y'all, I'm going to take just a short break and run to the restroom, so don't start before I get back, okay?
Okay.
Any questions? That's what that would or vice versa. Wow. How's the last trying? Yes.
Yeah, I think.
Do we think we have enough time to go back? Let's go.
Excuse me. Would y'all be amenable to stipulating to the exhibits that are in our petition
That's going through.
to just moving them into evidence?
Let me look at it.
Yeah,
And I'll tell you.
sure.
Attorneys for
I'll make sure.
petitioners can,
It's here. We'll need to figure out what we're doing. That really is a thing. They didn't have time to do this. We think we should have a steer.
attorneys for petitioners, can someone send me a share file to your exhibits, please?
We will do immediately after the hearing, okay?
Yeah.
Or I'll try to do it now. I don't have great internet connectivity.
I understand if you can't do it now, but the sooner that you can do it, the better for me.
Okay.
Thank you.
I'm scared of this tonight.
I've made it through, I have made it through December without sick kids. Yeah. Yeah. Yes, I've got that.
Just in
Safest person action. Yeah.
Right now. And they're serious. It's all you have to find out.
Investigator, come on up. So what you're trying to get is a dump from the tower for that window that will basically say, here are the 500 phones that were hitting the tower. But because you're looking for a bunch of towers, because you know where these guys were in the Bronco or whatever else it was, like, hey, this is the only number that's in all three of those places. And so it's sort of like a geofence, but a kind of crude version.
Yeah, it is. And then also the Bronco itself, if I was to, yes.
Okay, got it. No, that's, all right, then I get it. And we think it's the same guys, it's just two different days. They had two different stolen cars when they were doing it. Hey, I was with Chief Smith today at a meeting, like, hey, we need to add entering auto to things that can divert. It's like, we are not doing that. Entering autos, they're run by these guys, they're big teams, it's usually gangs and they're high vol. This is a business. I was thinking of like the homeless guy who breaks into a car to take something. He's like, we're not going, that's not divertible. Now that I read this, I should have read this just before I went to the meeting.
Yeah.
Like, I hear you, Chief. He didn't like that idea at all. Like, all right, I'll drop it. All right, you swear or affirm that the contents of your affidavits are true and correct to the best of your belief and knowledge.
Yes.
Excellent. Sorry for the wait.
Okay.
But you could see we were busy. No one was playing video games or whatever. All right, so you need to sign. Do you have a pen or you need one?
I have one that's black.
Blue's better. Here you go. Here's your folder. Do you want a paper clip or just a folder?
That's fine.
With so many vehicles with the Bronco. How do you do that? I mean, they're just punching the windows.
Punching the windows, taking things, electronics.
Guns, yeah.
Yes.
It's amazing how many people leave them in the car.
Still calling people.
All right, and then if you sign right there. Great, appreciate your patience. Good luck out there.
I appreciate it. Thank you.
Yeah, she's All right, let's get back on the record, please.
We're back on.
We're back on. Excellent. Thank you, Ms. Nichols. We're back on the record in the Humphreys matter. And you said one or two questions left.
Your Honor, I have even better news for you than that. I am about to take my seat and I have no further questions right now for Ms. McCoy. I did have two administrative things I wanted to address with you just before I sat down. The first is that during the break, we consulted with opposing counsel about admitting exhibits or stipulating to exhibits 1 through 14 in that binder in front of you.
Okay.
Those were attached to our petition. Opposing counsel, and they can correct me if I'm wrong, but they have agreed to stipulate to the admission of 1 through 14. For exhibits 5 and 6, they have stipulated to its authenticity only, though. Not to the contents.
Got it. Which is an affidavit of a last name I can't pronounce, and then Bandrowski, 2 affidavits. So
that's correct.
They'll be made part of the record.
Yes.
Of this proceeding. Someone needs to get those exhibits to the court reporter who will be creating that record. The respondents aren't saying those affidavits are accurate or correct, but yes, those are the sworn affidavits of initials DAC as well as initials LB.
Yes,
okay.
Your Honor.
Is that a fair statement, Ms. Piper?
Yes.
Okay, done.
And the second administrative thing I wanted to mention before I sat down, Your Honor, we had subpoenaed Ms. McCoy's personnel file from the Cobb County DA's office. I believe Cobb County ADA is in the room with those records. They have not been redacted because of how quickly this hearing had to happen.
Right, I think the subpoena was from this morning.
That's correct. And those records, as I understand it, are available for you. We are not able to look at it because they have not been redacted. I just mentioned that because they are, I believe the Cobb County ADA is here in the courtroom. Those records are available for you, but we don't know what's in it.
And given what I've shared on the record about my view of the existence of a conflict, do you think that there is a need for me to look at those records, or should I get them at least and put them in a sealed envelope so that they're made part of the larger record? Because I'll tell you, I wouldn't likely look at them to reach a judgment about the existence of a conflict. That's not me then saying, so what about that conflict? But at a minimum, the appearance of a conflict. And that's really what guides this analysis, how a layperson who sat through the trial in Glynn County day after day, seeing Ms. McCoy do the amazing work that a victim advocate does, not with the defendant, but with the families of the victims, then seeing Ms. McCoy in the room for a clemency hearing, that neutral observer would say, how is this the right way to do things? And it doesn't impute anything to Ms. McCoy, just on the surface, it speaks of conflict. So because of that, I don't know that I would look at those records. That doesn't mean you can't make them part of a larger record so that more powerful judges could look at it in the future. But obviously that should be sealed because it shouldn't be readable, even if it were redacted. It's a personnel file.
That's right.
And so I'm offering that up. If you want to, you don't need to get it to me, you'd get it to, well, I don't know how we would handle making it a sealed record.
Your Honor, may I take a moment to confer with my advisor?
Why don't we do this? Because who has the files?
I do, Judge. I probably should clarify. My name is Jesse Evans. We've met before.
I know you, Mr. Evans. I've been wondering because Mr. Evans keeps sliding over so I can see him. Like, no, hide behind the lawyers.
I'm trying to see the proceedings.
Yeah.
So, for a court reporter's benefit, it's JSSE, EVANS, and I'm Chief Assistant District Attorney with the Cobb DA.
Yes, you are.
I have 2 sets of records, or actually technically 2 sets of records that were requested this morning. And if you deem it appropriate, I can clarify what I have in my possession.
So my thought is this for everyone, but then I'll get Mr. Evans's input first, then petitioners, then respondents. Because you subpoenaed them, there was a felt need for them. They're not irrelevant writ large. I don't think I need to process them for the work I'm being called upon to do. So unless you want to abandon the request so that Mr. Evans goes home with those copies and then destroys them, I will take them and then we'll figure out how I can get them under seal and then united with the good work that Ms. Nichols is doing. I don't think they go to Ms. Nichols because they're going to be under seal. And so my proposal is either, one, you say we abandon it based on what you said, Judge. If not, it's okay. Then I'll take them and my staff and I will figure out how to get them filed under seal under this CV number. So they will travel with the docket should this docket need to go to the Supreme Court of Georgia or somewhere around there, United States. So we'll do that. I'm good with either one. The federal defenders really want to talk.
Yes, I'm going to turn it over.
If you don't.
You need to let Ms. Nichols know who you are.
Hello, I'm Beth Wells. I'm with the federal defender. I represent Mr. Humphreys. I was the one who was responsible for the subpoena, so I thought it might be easier for me to address. There are actually two categories, and they may have, one category actually goes to Mr. Bennett. And so that might be relevant to considerations the court is having. And I have not had a chance to speak more at length with
Mr. Evans.
Mr. Evans, thank you. I know that he was bringing the personnel file at the time we spoke this morning. He wasn't sure if he'd be able to get the stuff relevant to Mr. Bennett.
And remind me, I read the subpoena. The part for Mr. Bennett would basically be communications with the Cobb DA's office about the role Mr. Bennett's office, the sheriff's office, would play in connection with the case.
Yes, Your Honor. And actually, it would have been, unfortunately, because the hearing is truncated because of the warrant, we were hoping to have those so we could review them in our cross-examination or our examination of Mr. Bennett.
Okay.
I don't know what's in there, but we would like the court to have them.
And Mr. Evans, you mentioned you had two things, not one thing. Is one of the things, whatever you could find in 38 minutes, related to Sheriff Bennett, and the rest is Ms. McCoy, or is it all Ms. McCoy?
I don't know, so I'll tell you what our two categories are, and I'll explain the.
I'm sorry, I can't hear him. He needs to come up to a microphone.
Okay, we can hear you though.
Great,
All right.
I'm closer to a microphone now. So the answer to the judge's inquiry is, I don't know whether there's any correspondence between our office and Mr. Bennett in this file. I received word around 8:30 this morning of the existence of the subpoena. I asked my staff to start looking for things. And then it was only about noon that I was able to go by the office to pick up what I have. In one file, I'm certain that it's Ms. McCoy's personnel file. For the benefit of Ms. McCoy, who's a former colleague of mine, it has not been redacted, which is why we wanted to make sure it's under seal, because there would be some personal identifying information there that she wouldn't want out there. The other file that we were able to locate that might have correspondence with Bennett, I don't know because I haven't looked at it, I flipped through it, is what I'll call as our victim witness work product file that we located with the file.
Got it. But really, that would be probably more connected to Ms. McCoy's work as opposed to what I understood the thrust of the petitioner's request was, is there, I don't know why it would still be there, but communication from whoever was it Pat Head who was the DA back then?
That's correct.
Between Mr. Head or the judge who handled the case, not that your office would have communications from the judge, but Cobb communication with the sheriff's team saying, here's how this is going to work, and we need you to just keep your eye on the jury, or I don't know what, I don't know why that would be in that second collection. I appreciate you getting it. I think it was the right thing to do. My guess is that there's not going to be much in there either. But here's my proposal. I will look through the second folder that is victim witness related to the trial to see if there's anything related to then Sheriff Bennett. And if so, and it seems disclosable, I'll get it to both sides. So you've got it. And we may need to reopen the record in this if we are under less time pressure given the decision of the board from earlier today. I don't think that's going to jump out of there, but who knows? So, but if there's nothing in that second file that relates to Sheriff Bennett, then I'm just going to seal it with the other McCoy documents, because I think they go not quite hand in glove, but it's at least like elbow and shoulder, because it's victim witness advocacy connection to the Humphreys trial.
I did see some email correspondence between our team that presumably was collected by Ms. McCoy and kept in there that involved attorneys and things like that.
Yeah.
So it's not, it wouldn't be out of the realm of the possibility that maybe there's an offhand reference to Bennett.
Right.
But this is not the entirety of our work product.
Nope.
And so
You got what you could in the window you had.
you've hit the nail on the head, Judge.
All right. I appreciate your office's effort. I'll take it. Before we do that, Ms. Piper, you all right with the approach I described?
Given that I've already heard your opinion on the relevance, yes, sir.
Okay. All right. Thank you, Mr. Evans.
Thank you, Judge.
All right. Same. So you all understand, Judge Krause, she's in Hawaii right now. All right. She better bring me back a lot of whatever is good in Hawaii.
Macadamia nuts?
I don't actually like those, so coconut. I like coconut. Give me that.
Last administrative matter, Your Honor, and then I will sit down.
Can I take Ms. McCoy off the big screen there? All right. Don't run away, Ms. McCoy. I'll just take you off the spotlight right there. Thanks.
Your Honor, as to the remaining exhibits in the binder, those are exhibits 15 through 22. 21, excuse me, 21. We understand that opposing counsel has objections to those exhibits. We believe we could have entered those through the direct examination of Ms. McCoy had this not been a truncated proceeding. We ask that it be part of the larger record because under the exigent circumstances, we can't be here until 10 o'clock at night.
No, you can't. Well, you can. The door locks behind you. So why don't we do this? 1 through 14? Is it 14? Are admitted by stipulation. There are 2 exhibits, the affidavits, they're admitted. The respondents aren't admitting to their veracity or accuracy. And then 15 and 22 is also admitted. That is the bio for Mr. Bennett. So it would be 15 through 21. We'll make part of the record. I haven't looked at them. I'm not going to look at them, but I'll rely on petitioner's team to get them to Ms. Nichols to be made part of the record. But the record right now is making clear 15 through 21 are not in evidence. They aren't things that I will be relying on in making any of the decisions that I'm being asked to make. Does that address the administrative concern?
It does. It
Ms.
does.
Piper, does that work for respondents?
Yes, Your Honor.
Okay.
And with that, Your Honor, I will go and sit down and turn it to my colleague, Mr. Greenermeyer.
Okay. Well, it was nice having you up at the podium. Mr. Greenemeyer, what more is there? We've had argument. Both witnesses have testified. We haven't heard anything from respondents yet.
I would like to ask 3 lines of question to Ms. Smith, which are, who did she communicate about McCoy with? If she can give us any more guidelines about what recusal versus abstention means, right? Any representations. And in Fugate, there's a line that the Judge Goger found important, which was whether this was precedented or not, whether the board has ever conducted business like that. And I would like to pose that question to her.
Whether the board has ever conducted business with less than all 5 people there.
And voting, yes.
And voted.
In a death case.
Okay. It was helpful to get a preview. Ms. Piper, do you have any objection? I know they weren't the specific questions, but it was the 3 topic areas. Topic 3 seems like fair game. I'm all right with that, insofar as Ms. Smith knows. What about the other 2 areas?
I would say with respect to, a definition, in particular that Ms. McCoy has used in abstaining. They've had the opportunity to question Ms. McCoy on that. It's not what Quan thinks is the definition versus a definition is not really relevant. She's a legal ethics officer. That's it. She's not speaking on behalf of respondents in defining this term.
Okay.
To get her to testify as such, I think would be inappropriate.
Okay. I'll let you explore those areas. I may close things down on the Ms. Smith's views on what Ms. McCoy thinks. I know that's not quite how you framed it, won't be so relevant, but I think it is, given the amorphousness of abstention where we are right now, I'll let you ask Ms. Smith some questions in that area.
Yeah, and to be clear and to further preview, I'm not asking questions about what the definitions are, but what the practical effect would be when the hearing goes forward.
Okay, well, that's different, and that I'm all right with that. The one thing I just don't know how exactly the relationship between a board member and Ms. Smith works. If a board member comes to her saying, I've got this situation, could you give me counsel? Is that something you're allowed to ask about? In other words, is that a privileged communication? I'm not asking you to answer that, but you shouldn't be surprised if there's an objection. I just don't know the nature, how you would, what the confines or protections would be for a communication that Ms. McCoy had with Ms. Smith about, well, what do you think I should do with this? I'm new, I'm reading these ethical guidelines. What's your counsel?
Yes, and to be clear, what we'd be asking for in that first category is what communications did Smith have about the facts of McCoy with the other board members? Do they know, did she have any conversations with the other board members about these facts?
Okay. All right, let's see where it goes, and you're free to continue to object.
Okay, and just for the record, on topic number 3, I just would ask that the court circumscribe the questions to within an area that, you know, what the board does and how they vote and things like that is not open to the public. Okay.
No, I agree. To me, it would be very structural. Has there been an instance when only 4 members were in the room and voted? Not how did they vote? Nothing like that. We'll both shut that down. But it would be, yeah, you know what? On Tuesdays, it's 3 for Tuesday. Only 3 people in the room. So, all right. Ms. Smith, you still with us? You are. Excellent. Did Deputy Gordon leave? Deputy Gordon? All right, I'm gonna try. You raise your right hand. Do you swear that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Great.
Thank you, Ms. Smith. First question. Have you communicated about the facts underlying McCoy's potential conflict of interest with any of the other 4 board members?
I have communicated with the chair, Joyette Holmes, about the issues that have been brought to my attention by counsel for Mr. Humphreys. I don't recall having any conversations with the other board members about the issue.
Okay, so that was, you said Miss, who was the person that you communicated with?
Holmes, Chair Holmes, Joyette.
Okay. And this was the Joyette Holmes, who was for a period of time the elected DA in Cobb County? Okay.
Yes.
Okay, so if we have a situation where Ms. McCoy is not recusing, but she is abstaining, can you give us any idea how that would work from a logistical, from a practical standpoint? Can you give us any guarantees about what that looks like?
I think how Ms. McCoy framed it with the court is we would follow the court provides.
I'm sorry, hold on, a cough obliterated what you said.
Sure. We would follow the direction of the court. This is a case of first impression for us at the board, at least during my tenure. I've been with the board since 2005 and my current position since 2010.
I'm sorry, I'm having trouble hearing Ms. Smith. There's somebody that's not muted and their voices are coming through.
It
may just be background noise of Ms. Smith.
It may be. We'll try again. So Ms. Smith, you've been working with the board since 2005.
Yes, sir. In my current capacity since 2010.
What was your capacity for the first 5 years?
I was number 2 in this position. So I had a predecessor who was the director of legal services in 2005 to 2009, 10, something like that.
Got it. Then you got moved up to being legal counsel.
Right. That's right.
And when you say unprecedented, meaning in your 20-ish years working with the board, there hasn't been a situation where a board member has said, I've got a conflict, we need to figure out what to do with that.
Oh, absolutely. In a death penalty case, absolutely.
Okay.
My lights go out when I don't move.
All right, feel free to wave your arms. I can swear you in periodically. That'll get your arm up.
Okay, so again, I appreciate the representation that you will follow what the court tells you to do, as we all will. But in the absence of a court order, can you tell us anything about what McCoy will do or will not do in connection with this clemency hearing? Is she going to be there? Is she going to be allowed to talk? Is she going to be allowed to sigh? Can you tell us anything that we can take to the bank about her involvement in the absence of a court order?
Sure. My understanding is she would be she would not vote on the matter, but be present to hear the application and the information presented to the board in support of and or against clemency. And that would be the extent of her involvement. In addition to what you were asking, would she be able to ask questions? Yes.
Ms. Smith, when the presentation is done, is it kind of like a jury trial and the people who presented leave and then the board members confer and say, hey, again, I don't want any substance of the conversation, but the process, they then talk about it and take a vote in private with no one present? Or do they, in front of everyone else, say, all right, what do you think? And they raise their hand saying, spare him.
So they have an opportunity to deliberate collectively. And then if they so choose to cast their votes are confidential and private. So they would designate their votes on a paper ballot and submit those ballots to me. They could do that in the presence of the other members or in private. And once the ballots are collected, I will get with the chair and we will go through the ballots and count up the ballots to determine what the actual decision of the board is.
Okay, and your vision as to what abstention would mean for Ms. McCoy is that she would be there for the entire presentation. She could ask questions, and then when everyone leaves, she could be part of the discussion, the post-presentation discussion. She just wouldn't, if this is one of the ballots, she wouldn't fill out one of the ballots.
Yes, sir. That's my understanding as of right now. That could change based on the information that is indicated that if the court decides otherwise, that would not be constitutional. But as of tonight, yes.
Got it.
Okay. And just as a practical matter, can we agree that for Mr. Humphreys, there is no difference in effect between a vote to abstain and a vote to deny? Those are, practically speaking, the same exact thing for Mr. Humphrey.
I'm not sure I understand your question.
Mr. Humphreys needs to get to 3 votes to be spared, correct?
Right.
And so a vote to abstain is effectively the same exact thing as a vote to deny from Mr. Humphreys' perspective, correct?
Correct.
Okay. All right, and Judge already got us 99% of the way here. I want to direct your attention to a passage from Fugate and just make sure that we are in agreement about the unprecedented nature of this. So Fugate says, significant to the court, the respondents were unable to refute the petitioner's contentions that there has never been a death penalty clemency hearing without a full 5 member board not only appointed, but indeed present at the hearing or at least voting after a review of the record and the papers filed by the parties. As you sit here today, to be clear, you are not aware of any death penalty clemency hearing without 5 board members voting. Is that correct?
Are you thinking or did you answer and I missed?
I'm thinking,
Oh, good. Keep thinking. I just wasn't sure that there's a cough and we don't hear you.
I'm thinking, I am not aware of a situation where we've had a death penalty case, clemency appointment or meeting where 5 board members were not on the board and available to vote the case.
Thank you, Ms. Smith. No other questions.
Do you have questions for Ms. Smith?
Couple. Just
Great.
quickly.
Okay.
Hi, Ms. Smith. So if all 5 members come to you separately and the first 3 vote for clemency, would you even need to have the votes from the 4th and 5th member?
You do not.
All right. And in your experience, have there been occasions where 3 came in one way or another and you really didn't look at the rest, or you didn't get the rest, or whatever?
Yes.
All right. That's it, Your Honor.
I follow Ms. Piper's questions, but those scenarios are ones where nonetheless all 5 board members were present and able to vote, but it may be like, do you send up a smoke signal once there's 3? Because there's like no point in being number 4 or 5 because 5-0 isn't any better than 3-2.
So it depends, Your Honor, if all 5 are present in the boardroom after the appointment or the meeting and decide to vote then and there. Obviously, we have our votes and they're all in. If they decide that they do not want to vote in that manner, but want to take the matter under consideration privately, then a time deadline may be given or has been given as to when to get the votes in. And so when that deadline comes and goes, then we know whether we have the 3 decisions, and I will announce the chair will announce to the board members that a decision has been obtained and what that decision is.
Okay. Got it. All right. Thank you. Did you have any follow-up, Mr. Greenmeyer, after Ms. Piper's questions?
No, Judge. Thank you, Ms. Smith.
All right. Thanks, Ms. Smith.
Welcome.
All right. Any other witnesses?
No, Your Honor, not at this time.
All right. Any witnesses from respondents
No, Your Honor.
other than the ones you made available? And thank you for doing that.
We would ask if there's no further questions that they be excused.
Yep. So you are welcome to stay on our session. We're going to have a little more argument, but if you have other places you need to be, you are free to go. And thank you for your work on the board. What do you want to do next? I guess, Ms. Sino, you had a chance to do some arguing. I really haven't heard much from respondents. I guess I'd like to do that so that we can get a sense of where they think things are heading. And then we'll see if there's a need for rebuttal to that. Does that work?
I agree with that, Your Honor.
Okay.
Thank you.
Great. Ms. Piper.
Can you hear me okay? Court reporter?
I can.
Okay, great. Thank you. And since I have had the opportunity to argue a little bit, I will try and keep this very succinct and concise. I think that as you opened up in the beginning, this is a mandamus. I mean, there's a TRO, but they have to show likelihood. So we're going back to the merits. 2 issues. First issue is the abstention of voting. McCoy's out, so I feel like that's been mooted. You've heard testimony from Mr. Bennett. There's no personal involvement.
When you say that's been mooted, how do you navigate that ethical provision that says recuse as opposed to the introduction of the concept of abstaining, which doesn't seem to be in the ethical guidelines?
Yeah, there's a couple of things. One, I think as lawyers, we are very cognizant, words matter. So I would say, you could look to straight up to a Black's Law definition of abstain and a Black's Law definition of recuse and follow those. But I think also in terms of a board member who is not an attorney, they may be morphing those together and understanding those together. Do you know what I'm saying? As a board member, you're like, oh, well, abstaining, I'm not voting, that is what I have to do to avoid this conflict.
Sure. But it was your brief that said abstain.
Correct.
It wasn't, Ms. McCoy did not introduce the term into the process.
And I would say that is a declination to vote, a removal of yourself from the vote, not a complete absence from the proceedings.
So if she is present but can't possibly vote for clemency, to a point that petitioner's lawyers made, then doesn't Mr. Humphreys walk into that room with fewer chances to get 3 votes? He has to bat 750 instead of 600. And doesn't that change the dynamic in a way that's not fair?
Well, I mean, that presumes, that a vote's going to go any particular way, but that's not what the question is. Does he have a legal right to that?
You're right.
Not what are his chances, what are his odds, does odds go up this way or go down that way? The question is, does he have a legal right to it? Yep. And we submit he doesn't.
Okay.
So back to the rules.
Your position would be he has a legal right to a quorum, which is 3.
That is
if
correct.
you walk in the room and there's only 1 person, that's not going to work.
Correct.
But if there were 3, if for whatever reason I were to find, gosh, Mr. Bennett, you're disqualified as well. The 5 times you may have been in the courtroom over the course of a month-long trial, that's too much.
Correct.
So you also have to abstain. There would still be 3 people who could vote, and that's a quorum, and that's the right that Mr. Humphreys enjoys, is having a quorum.
Yes, Your Honor.
Okay.
All right, and I can, I think our brief is pretty clear and lays out. I want to just address that policy one quick last time, and I think I've already said this. There's certainly, you could argue, that I just don't think that a written policy that the board adopts, modifies at will, changes at will, rises to a level of requirement that the Constitution is, right? It's a difference. And the Constitution, if we look at, and I'll just go straight to the heart of what they're pinning, this whole linchpin on the constitutional provision, I think it's Article 4, Section 2, Paragraph 2D, the chairman of the board, blah, 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 may suspend the execution until the full board shall have an opportunity to hear the application of the convicted person for any relief within the power of the board. It does not, first of all, it's not mandatory. It's he may, right? And that, when we say may, words matter. It's precatory. It's not mandatory, right? There's discussion there, but it's also the full board have an opportunity. It says nothing to the declination of availing themselves to vote, right? It just doesn't speak to that. There's a heavy emphasis on a case that is non-binding, that really, if you look at the holding, what fugate stands for at most is you got to have 5 members appointed. That's what the Constitution requires. We have that here. That hasn't changed. And, I just, in our brief, it hasn't been really talked about much today. So I want to kind of go there and then hear from you what you'd like to hear from me. The relief they seek. I mean, they're not only is there no clear legal right to that relief, there is no legal authority to get there. There are 5 members appointed. The Constitution gives you 5. That's it. No less, no more. The governor can't appoint someone to fill any role of a member who's abstaining.
Because that would make 6.
Because that would make 6.
Because I'll tell you what I've wrestled with, the way it works with the Judicial Qualifications Commission. The hearing panel, so the body that would handle the trial of a judge, has 3 members. Every once in a while, the member may have a conflict. I did, because they were figuring out what to do with a judge on our municipal court. And the rules are real clear. You can't be the hearing officer or the chair of the hearing panel for a judge who's from your circuit. But that didn't mean we went forward with 2. It meant that the Chief Justice appointed another judge to fill the judicial position of the 3-member hearing panel. I don't know that that's all, certainly not in the Constitution. I don't know that's spelled out in the rules, but it was, we have to do something, because what is in the rules, what is in the policy is if you have a conflict, you recuse. I thought it could be fair, but it doesn't matter. It's a structural conflict. We're in the same circuit, so I shouldn't be in that group. So they find a judge from another circuit. She parachutes in and she handles it. Well, technically, did we have 4 people on the hearing panel at the time? You could count, and maybe, but one was interim while one was recused and not functioning as a hearing panel member. Isn't that how it would work here?
No.
No.
And you know, I
It's a
appreciate.
quick answer.
I appreciate that is a system that you have legal authority to do under the JQC. That is not the case here. The Constitution is very clear, and the law is very clear about what authority the governor has with respect to that board. And he has 3 different scenarios where he gets to play, you know, remove for cause, remove because they're incompetent, or, you know, they're very, very, you know, incapacitated, unable to perform. There's no other legal mechanism for him to just like slide someone in there. And
he appoints everyone on, it's not like some of these government agencies where the president of the Senate appoints one and the Speaker of the House, the governor appoints all 5 members.
That is correct. They do have to be confirmed.
But the governor is the selector of, or propounds the nominees for each.
That is correct. And just, I guess, just to finish kind of where I was and got excited and moved around.
Sorry.
You know, I think at most, Fugate stands for that proposition that, you know, you have to have 5 members elected. So even, you know, and as we've set out, the law very clearly establishes, and it's in our brief, you know, under 4297, a quorum is all that's needed to quote unquote legally transact the business of the board. You know, that includes the board's business of ruling on a clemency application. That is the board's business. So even if 2 abstain, we have a quorum. And under Georgia law, the minimum number that we need for a quorum to conduct the legal transaction of the board's business, which here is review of a clemency application, is met. And unless you have further questions, we'll rely on our briefs.
I do have a question.
Okay.
Is there something in the law that says the governor could not appoint an interim board member?
Well,
or what you're saying is it says these are the 3, you can do it in 3 instances. Because you've removed someone resigns, or the 3rd one would be, but because the law is silent about, well, you know, if someone says, because there's a policy that says you should do this, I need to recuse from this one. Let me ask it in a different way. What if 3 people had to recuse? Then there's no clemency hearing? You can't do it?
in that hypothetical,
That's my hypothetical.
your hypothetical.
3 people are recusing. What do we do?
I would think that, you know, the governor would be faced with a decision on whether he would seek resignation of one if he needed to replace one.
So that someone would actually have to quit.
Well, here's the thing about the executive branch, okay? Typically, you have authority that is granted by the legislature, and it extends no farther than that authority.
At least in Georgia.
Which is either, directly or by implication. There is not anything that I've seen that would say by implication, he has this authority.
Okay. No, we're clearly in this liminal space. In my scenario, I don't know how you'd have three people who had a recusal, but it comes up. And then what do you do? Because you need a quorum, which would mean you need three, and you don't, you only have two. But the answer wouldn't be, well, then we're just not going to give you a clemency hearing. It's too bad that your situation was so high profile that three people recused.
Hopefully our board will never be comprised in such
hope.
a manner that we
Yeah.
face that question.
Okay. All right.
Thank you.
Thank you. And I appreciate, this was dropped on your office with exceedingly short notice, and that's not a knock on the petitioners. Everything is rushed at the end, but you guys, it's always fire drills, and it's still well put together. So thank you.
I can't take credit for that. It was a team.
I figured it's not just one person, but that the team continues to deliver. So thank you. Ms. Sino or anyone else of the table of five, but please identify who you are if you're talking.
Yes.
What do we do with you can't have six, you can only have five. And if really what has to happen is that Ms. McCoy should recuse and not participate in any way, because there really ought to be a chance to have five people to convince and not four, because it really wouldn't matter what your team said. It's impossible to convince Ms. McCoy. That's the wrong way to put it. It's impossible to get a yes to clemency vote from Ms. McCoy because she's not voting, and she shouldn't vote. But then I agree with Ms. Piper. It's not right to say, well, now he has to bat 750, but factually, he has one fewer opportunity to convince someone to get a yes to clemency vote.
Right,
But you can't have six members.
you cannot have six members, you have to have five, but under 4291, the governor has the opportunity, if he receives information deemed to be reliable, if a member of the board by reason of illness or other providential cause is unable to perform the duties of the office, he gets to appoint somebody new. And it doesn't have to be subject to the legislature confirming it. Right? If the legislature is not.
Someone new who forever replaces the person who's providentially unavailable?
So this is the part under D, any such appointment, if it's made at a time when the Senate's not in session, can be effective ad interim. It can be interim.
Okay.
The legislature is not in session right now.
But what if it is? What if, because this has been, assume for a minute, there's some master chess players here and like, hey, I guess though after the 24th, you have to get a new warrant. But anyway, there's a new warrant, execution warrant that's secured. And now it's time to have the hearing, and it's March 10th. Legislature's in session. And Ms. McCoy is going to remain providentially unavailable for purposes of your client's clemency hearing. What then? He has to go to the legislature to get an interim appointment, or bizarrely, interim appointments are only available when the legislature's not in session?
Well, no, I mean, there is a whole process that is set out, right? If we start with Section A, he has to call a council to be composed of the president of medical association, et cetera.
I'm sorry, I can't hear you.
I'm sorry, and I didn't. Okay, 4291.
Yes, no, that's on my computer. It is
asking what you're referring to.
sure. CGA 4213-2.
So hold on, you've pivoted. You had said 4291. Was that a miscite?
Sorry.
Or both statutes
Sorry.
play here.
Sorry, I'm looking at the very top of this. It's 42-9-12. My apologies.
So neither. All right.
912.
42-9-12.
Got it.
My apologies.
That's okay. I
And
just
this is,
wanted to make sure we're reading the right statute.
yeah.
All right, 42-9-12.
42-9-12, governor receives information, somebody is unable to perform duties of office. He shall call a council composed of the Medical Association of Georgia, president of the State Bar of Georgia, commissioner of public health, to determine if that individual is not able to perform duties. He can appoint some other member. Right. What? Yeah. And it operates as a temporary suspension.
Okay,
It's just a temporary suspension.
okay. So 42-9-12, I'll have to explore that, but you made it seem like it was contingent upon the legislature not being in session.
If the, so it,
I don't mean to put you on the spot. I'm
No,
gonna
it's-
read it and I'm gonna give people a chance to respond to that, but
I was looking it up as she was stating that we can't have a sixth person. But because it does state, let me see. Go ahead.
Senate's in session, that goes to the Senate. If not, it's out interim.
Yeah, it's D. If the Senate's in session, it has to go through the Senate. If they're not, it's ad interim. And that's the statute.
But if they're in session, it goes through the Senate for them to approve the interim person, or it's a completely different beast? It's the same concept. Someone is providentially unavailable, and if they're not in session, then the governor plus this board would decide, here's our interim replacement. But if someone is providentially unavailable, I broke my leg and I can't, it's really painful and I can't come, we got to do the clemency hearing, they can draft a substitute. And either it's Senate approved if they're in session, or it's special board approved if they're not in session.
So it seems to indicate that it is interim because then Part E says during the period of incapacity of the member of the board, the member shall be entitled to receive compensation and other benefits.
Okay.
So
I'm going to have to get cozy with 42-9-12.
42-9-12.
All right.
Two different concepts. It's an interim seat. The appointment, whether at interim or Senate, it's a permanent person or an interim person. Doesn't make sense. So if you appoint somebody for the interim, the way the appointment is made to the board, if the Senate's in session.
Right, or not.
But it's just interim. And it
Yeah.
also applies to those two things, like we're mixing those two things together. You see what I'm saying? Like they're an interim seat.
They're an interim seat no matter what.
Right. And how they get appointed just depends on whether or not Senate's in session.
Right, I think that's what
Yeah. Thank you.
I think that's what I stated.
Okay.
They're an interim seat no matter what.
Okay.
And either there's an appointment process out of legislative session or in.
Understood.
Yes.
Other things you wanted to add?
Other things I do want to add. If I can share a PowerPoint. If we
How long is the PowerPoint?
12 slides.
What's it about?
Just detailing the Georgia Constitution and I can just briefly summarize. How about that?
Excellent.
Does that make it? Yeah, it's late. Okay. I want to say earlier you asked for a hook on the ethical guidelines. So OCGA 45-10-3, those impose mandatory duties on employees, on our officials, and that's where the hook is. They have to follow their ethical guidelines. That's the statutory provision.
All right.
I also want to talk about the abstention. Abstention does not fix the problem. Abstention means we effectively have Mr. Humphreys starting one vote down, a no vote, and that is not constitutionally effective. It means Mr. Humphreys already has one vote going in that's no, and the Constitution states that it has to be 5 votes. And I know they want to really parse the words and say meaningful deliberation. As long as she's not voting, we fulfill our requirement for 5. But under OCGA section 42-9-20, in all cases in which the chairperson of the board or any other member designated by the board has suspended the execution, which has occurred, of a death sentence to enable the full board to consider and pass on the same. Consider and pass on the same. That sounds like a vote. It shall be mandatory that the board act with a period not exceeding 90 days from the date of the suspension order. And I realize that's about the 90 days, but it contemplates that they are passing on that. They're not sitting there and listening and simply occupying a seat.
Okay. That was a good summary of the PowerPoint. I don't know, it was in the PowerPoint, but it was a lot faster than 12 slides. Thank you.
And then finally, there is one last part, which is Fugate. We are in the Fugate situation right now. There are only 4 members because the abstaining member can't vote. And Fugate requires to have that 5th vote, not a 5th person, a 5th vote. And it's very, very important because clemency is so different.
Why is clemency different? Meaning because the outcome of a failure to get clemency is fairly profound.
If Mr. Humphreys has an execution, let's say they restart that clock tomorrow, we're going for a clemency hearing, there's an execution, whether it's Thursday, Friday, or next week within the warrant period. The next day, we can't wake up and say, oops, we got it wrong. There has never been 4 people voting. They said that themselves, and at least since 2005, there hasn't been 4 people with a vote and just a no, just going in 1 vote down. That seems ridiculous to say we're going to start that today. And Fugate stated, a 5th board member, the opportunity to present a case is unique and firmly rooted in the criminal justice system when it comes to clemency. A 5th board member might be persuaded by the petitioner's case and may well be able to move others on the board to favorably consider a reprieve. It cannot be discounted, that 5th vote, that 5th member. That's all I want to say.
All right. Thank you. Ms. Piper?
Very short.
That's okay. You have listened mostly this afternoon. So if there's one very short thing or some short thing you want to share, let's do it.
All right. I'd like to point out incapacitation, providential cause, do not in any way, we're shoehorning conflict in there. It's just not applicable. And then I would like to, again, the 5th may talk them into clemency. The 5th may talk them all into not giving clemency. That's all speculation, and it doesn't matter because at the end of the day, yes, death is irreparable, but he has no right beyond what the state of Georgia has provided him in his application for clemency. So you can't say he's harmed if we are providing
that option as dictated by the mandates of the Constitution and state law. That's all.
Okay. Thank you.
Your Honor, can I add one more thing? Sorry, it's very quick.
Okay.
That suspension can be lifted at any point. So the TRO is incredibly important for the 90-day stay, for them to appoint somebody new. That if they lift that suspension, we have to go right into clemency proceedings, and we don't even have the witnesses ready to go. If that thing's not occurring tomorrow, then we don't know when it's happening, and we will not be prepared.
Let me ask a little bit more about that, and you don't need to worry about responding to that. I that's a important point, just different from what we've been focusing on, is you or your colleagues have brought it up several times. So I've never been to a clemency hearing. Apparently, it's not just one witness saying, hey, show some compassion. It sounds like you have a whole host of people you intend to call, and they were lined up for 9 a.m. tomorrow. So there are people like landing at Hartsfield right now who are going to have a great dinner and then be told, get back on the plane because nothing's happening.
And I'll let my colleagues speak more about the.
Well, I don't, because it's 5:40, want to get into all the blocking and tackling involved. You're helping me understand. It's not just the lawyers and then Mr. Humphrey's mom saying he was a good kid or he was an abused kid. It sounds like there are many, many, many moving parts. And so being told, hey, let's do it next Monday instead isn't necessary. As much notice as possible is critical to get all the people there.
Absolutely. It's mental health professionals, it's character witnesses, it is the lawyers, but it is a large moving machine. It's almost like a mini mitigation trial.
How much notice did you have that the clemency hearing was going to be at 9 a.m. tomorrow?
Your Honor, this was quite a short warrant that we did not see coming. It was.
I'm sorry, I can't hear who's speaking.
You know how it works in here.
Beth Wells. We got the warrant December 1st, and we were caught off guard by it because for things not relevant to this court today, we then had to quickly move to get people brought here. It is right before Christmas, which has made things incredibly difficult.
Okay, but my question,
yes.
So you were able, so tomorrow's the 16th. So in basically 2 weeks, through Herculean efforts, you were able to get everyone there. Anything shorter would be even more difficult to do. Got it.
Yes.
And do the way the warrants work that they could apply for a new one and hold on one second. Could you get not you wouldn't obtain it, but could the district attorney obtain a warrant that, I'm making the dates up, but because the 24th is when, well, this one expires. So what would happen? They could unsuspend that the board could on the 22nd say, we unsuspend, clemency hearing is tomorrow, the 23rd, and execution is Christmas Eve, 7 p.m. because the warrant expires at 10 midnight on the 24th. That is procedurally permissible.
They could unsuspend the minute we walk out of this courtroom.
Okay.
And they have unsuspended a day after they've entered the order suspending. We have had that happen.
In other cases?
Yes.
Okay,
So
got it. So this is you're flying blind as to what's going to happen.
And yes, and that is why we're requesting that
The
they
TRO.
sign a TRO, or at least to the extent of not having an execution under this warrant.
Okay.
Until the court rules.
Got it.
Thank you.
Okay, you're welcome. It's a new set of mechanics. Okay, so I need to get Ms. McCoy's records filed under seal. That's one part of that document, set of documents. I'll look through the other part to see if there's anything that needs to be disclosed that it relates to Mr. Bennett. And then there's the question about the TRO just to maintain the status quo, which today the status quo is that the execution or the warrant is suspended. And that's the status quo that a TRO would maintain. but the more fundamental ruling is when there is a clemency hearing, who is up? Are they at a dais? I don't know how they sit, but who is Ms. McCoy up there? Are there only 4 people there, or are there 5 people? And it involves this interim appointment. Okay. Anything else from petitioner?
No, Your Honor. Thank you.
From the respondents?
Just one housekeeping, and I think I heard that you understood this. I just want to make sure you did. The order from the board the suspension has to be lifted before a new warrant can be sought for execution if the warrant that we're on now expires.
Got it.
Okay.
So no, but I'm going to play this back because I didn't know that. Not because someone told me something contrary, but this order suspending means the execution can not go forward until it's lifted. If this order is in place and I'm opening Christmas presents, then the warrant has expired and no new warrant can be sought until this order is lifted. Once the order is lifted, someone can seek a warrant, and then how long does the warrant live?
It's a 7-day period.
Oh, it's just 1 week.
1 week.
Oh, okay.
No, actually, the warrant is between 10 and.
I'm sorry, I can't hear who's speaking.
We're going to go off the record now, okay? I'll let you know when we're back on the record.
When a warrant is signed, the execution period starts between 10 and 20 days from when the warrant is signed, and then it's a 7-day period. So it can be up to 17 days or up to 27 days.
Okay.
At the limit. And just
Complicated.
it is.
Okay.
To clarify, Your Honor, you are correct to exactly what you said. If we make it to Christmas Day and that's still in place, they would have to seek a new warrant. Our concern is between now and the 24th, if they tear that up.
I understand. No, I got that. It was helpful to know that if this isn't lifted, then they can't even get another warrant till this is lifted. How do I learn when this is lifted?
We would offer to ensure that the court got notice if it were to be lifted.
That would be great. I may need to enter an order to that effect, that I'm on the hotline. I trust that this team is on the hotline.
They are on the hotline.
Yeah, I just want to be added to the hotline. And the decision about lifting this is purely internal. It's the board. They confer, they figure out what they're doing with whoever their muses are. It's
Chairman or the designee.
okay. All right. Let's get back on the record.
Back on.
Thank you. All right. I will keep working on this, and I will certainly reach out if I have questions. Emails will always go to both sides, and we'll see what we can do with this. If anyone ever has a question, just reach out to Ms. Niles. Email is the most direct way to get to her. She'll let me know, and we'll work through it. And again, thank you to both sides. Everything is always so compressed as we approach that deadline. And it involves so many different layers of courts. We even have the feds poking in here. So I appreciate everyone's focus. And with that, you all need to settle up with our court reporter. She has done an excellent job of keeping us near microphones so that she's able to make an accurate record of the proceedings. So thank you for that, Ms. Nichols. And I'll rely on petitioner's team to get those exhibits to Ms. Nichols. Okay, well, just make extra sure. All right, thank you, everyone.
Okay, who is Beth Wells representing?
Here she comes.
This is going to pay your bill. I'm with Stacey Humphreys, and I will reach out with you as soon as I get back to the court about what we're doing.
Okay.
And how to get paid.
Okay, well, I was under the impression by what y'all said that y'all are splitting the bill for the transcript to be expedited and the court reporter. That's what y'all said at the start.
Correct.
That's still true.
Okay, and Ms. Wells, I need you to send me your, if What firm are you with, Ms. Wells?
It's with Ms. Conrad from the Federal Defender contacted you, that we are with the Federal Defender.
Okay, I have no idea who contacted me.
Oh, okay, right.
So I
I'm
need
with
you
the
to
Federal
send-
Defender program. I'll send you all of that information as soon as I just don't have internet connectivity.
I totally understand. If you'll do that ASAP, I'd appreciate it.
Thank you so much.
Thank you. Bye, y'all.
Bye.
Thank you very much, Ms. Nichols.
You're welcome.